strangers instead of a personal journey between supportive partners. Our penal code clearly prohibits the purchase of a baby. If you look at the penal code, which I printed out, section 25.08, the sale or purchase of a child, it's a very interesting read. It's right here in the penal code. Today, we are going to look at the practice potentially of commercial surrogacy. And is that being monetized? Today, digital platforms can match random people who want a baby for whatever purpose with a woman willing to offer their womb. What happens when we allow a payment to women for engaging in surrogacy or placing their own child up for adoption? When does a reimbursement payment blur the lines into becoming an incentive? What happens to fertilized embryos that go unused after a successful IVF treatment? Who owns those embryos? Can they be sold to a third party? Have our laws moved as fast as technology has moved? As fast as science has moved? According to national media reports this year, prospective parents outnumber available babies for adoption by 40-1 in the United States. To respond to that demand, what protections do we need to ensure that the baby business never becomes an actual business? The Supreme Court recently upheld the concept of birthright citizenship. Yet the practice of assisted pregnancies and giving birth is still largely left to the states. How does a large border state like Texas react to hospitals placing billboards in Mexico urging pregnant women to travel to our state specifically to give birth and directing them to the website havemybabyintexas.com, which I've been told was pulled down earlier this week, perhaps in advance of today's hearing, or perhaps with the governor who sent a letter to Commissioner Muth yesterday to direct an immediate investigation into the reports that Mission Regional Medical Center, a hospital facility regulated by the Texas Health and Human Services Commission, in advertising birth packages in South Texas in foreign countries and targeting such advertisement to foreign nationals in an apparent effort to profit from securing United States citizenship for their children. The governor goes on to say birth tourism is an illegal practice that exploits the extraordinary hospitality that the United States and Texas offer to millions of foreign travelers each year. Unfortunately, thousands of foreign travelers come to the United States under false pretenses to give birth and secure citizenship for their children. As governor of Texas, I will do everything in my power to assist federal officials to stop this fraudulent practice. That was issued just yesterday. The appeal of birthright citizenship spans far from the border to places like China, where billionaires can exploit our loose surrogacy laws. This has been reported in the media. You can do a simple Claude research, and you can find that California is where most of the reported abuse surfaced. Its permissive surrogacy laws draw the practice, prompting a 2025 raid in Arcadia, where authorities removed 21 mostly surrogate-born children from a couple with alleged CCP ties, and a widely reported case of a Chinese billionaire who used American surrogacy agencies to father over 100 children. Because commercial surrogacy is illegal in China, the billionaires pay American agencies, like I just quoted, millions to exploit the surrogate mothers and egg donors, granting the resulting children automatic United States citizenship, as again upheld by the Supreme Court of the United States most recently. In some cases, the babies are picked up from the hospital after a pre-birth agreement is presented, and the baby is immediately jetted off to China. Who are we as Texans if we do not address this issue? Texas is a pro-life state, we are a pro-baby state, and we are a pro-family state. And at the same time, we will be dealing with these issues today. We have thousands of children in our foster care system each year who would love to have a forever home, Commissioner. Let's also remember them in this discussion and do not forget them in the quest for parenthood. Our witnesses will bring very serious testimony today to each of us and to those of you in the audience and to those that are listening. And my hope is that we carefully examine this complex problem, and it is complex, and it goes deep. Each of us have been impacted by someone who could not give birth, who has used wonderful scientific methods to give birth. But there is an ethics that we need to be looking at. Our staff has discussed this in great length, and this morning my chief of staff said to me as we walked into the building, he goes, "Senator, we deal with a lot of things, and we've been in this building a long time. But today is truly about life." And it really is. So we will face this day with an open mind and a big heart. And we will also use our own moral compasses as our guide. I said a little prayer today. I left Brenham, Texas at 6 a.m. It was beautiful. Sun was coming up, and I'm blessed to live in the rural part of our state where the fog was hanging low to the ground and the hay bales had just, the hay field had been cut, the hay had been dried, and it had been rolled. And those hay bales were sitting out there, and you know what I did? Stopped and I took a picture. Now, anybody going down my road would have thought I was crazy in this suit out there in the middle of the road taking that picture. I actually got up on the back of my Tahoe and I took it because I wanted to remember it. And why did I want to remember it? Because that was a part of God's creation today. And He put on my heart, truly, do good here. Do good and do right. So I looked and said, Senator Hughes, I said, I think we're the first state and the first people to tackle this in the nation. Darn, Florida got ahead of us. I hate when that happens. Governor Abbott, I know you really hate when that happens. But in March of 2026, Florida House passed the FIRE Act banning surrogacy and pre-planned adoption contracts involving citizens of countries of concern, which was built off of, for everybody, Senate Bill 17, which happens to be those same countries I listed in that, China, Russia, and Iran. So it's just the beginning. We're going to open the conversation today, and we're going to keep working. Just like that beautiful sunrise this morning. I think God will put something on all of our hearts today. Say, do good and do right. With that, members, would anybody like to add anything to the opening remarks? Show Senator Hughes as being present. And so with that, a quorum is established. And members will get to it. The chair calls Christian Ross Jennifer Law, Tara, and I think it's Doss, and Steve Wolub. Yeah. Commissioner O'Neill, I think you're going to be a resource, so we'll pull up an extra chair, and I'm not sure where the extra chair might be. It's behind Steve, so we'll pull you up as a resource witness. I think you have some related cases that we may have to ask you about. Before we begin, just a couple of housekeeping items. We will first take up invited testimony, and then we will move to public testimony today on all charges. The committee uses electronic witness registration. If you wish to provide testimony, you must register at the kiosk located in a hallway outside of the E1.012. We will leave the witness registration system open during the hearing until a certain time that I will announce. And then public testimony, you will have 2 minutes to speak. And you know this is once I call your name, we'll do panels of 4 after the invited testimony today. We will begin with Ms. Ross. Welcome. Thank you for coming today. Thank you for coming.
Thank you for having
all the way
me.
that you traveled, and we're so grateful for your testimony today.
Thank you. My name is Kristen Ross. I'm a mother of 3, 2 sons and a daughter. I'm a former mother, a surrogate mother to a 4th child. I'm here today to share what happened to me and this child that I carried, to explain the issues and the exploitation that is happening in the United States from the rapid growing industry of surrogacy, and how I became embroiled in an international custody battle. I've known so many people have struggled with infertility, and their pain is what led me to become a surrogate. After feeling deep empathy for those who struggle to have children naturally, I was inspired to help. My intent was to help families that could not physically have children naturally, not those who wouldn't. I reached out to a larger surrogacy agency based in California who had matched me with intended parents. I was eventually matched with a foreign couple residing on the East Coast in the United States, the state that I reside in as well. Initially, I received the couple's profile, which contained an absolutely beautiful story about how they wanted to extend their family. They only had 2 children, as I was told, but unfortunately, they were no longer able to have children of their own. I really felt grief for this family. I really loved their story, where they hoped to bring more angel babies into the world, and their dream was to be surrounded by children and grandchildren. I love the pictures, I love their words, and I agreed to move forward with this family. This intended couple claimed that they would be using dad's sperm, and I would carry, as the intended mother wasn't capable of providing an egg of her own. Never in my wildest dreams would I have thought she couldn't provide an egg because she at the time was pregnant herself. Originally, the couple was supposed to come meet me before the process began. Unfortunately, they never showed up. However, immediately after the embryo transfer was complete, the intended dad and his assistant were on site to meet me. We spoke for no more than 5 minutes, and I never met the intended mother. I learned shortly thereafter that this is the same couple that was matched with another American surrogate at the same time, and they were attempting to conceive multiple babies. At one time, I had so many questions about the situation, but I felt it wasn't my place to ask questions upon their intentions to grow their family, as I was told by the agency that a percentage of transfers fails. And at that point, I was locked into a contract and I was pregnant. So even though there were red flags, I felt stuck. I, like most first-time surrogates, was new to surrogacy and the process involved. I know next to nothing about the legal process and what would take place. My agency did not provide an accurate explanation. Representatives from the agency would tell me one thing in an email and a slightly different version over the phone. The ethics around these agencies are very loose when it comes to accurately communicating to surrogates, and in some cases, the intended parents as well. Prior to the transfer of the embryo, I had received a detailed list and an inventory of all the medical interventions I needed to carry for this baby. I received multiple shots with medication, and before the end of the process, I wanted to stop. Even though it caused me great physical pain and it interfered with my ability to take care of myself and my children, I still went forward. Several weeks following the embryo transfer, I was at home following my normal routines when I felt painful cramping in my abdomen. I went to the bathroom and there was blood all over my lower body. I was terrified. Here I am carrying a baby for people who want nothing more than to be parents, and my body was rejecting him. I was rushed to the hospital right away. They took me straight into a room and performed a sonogram and deemed the baby to be fine, thankfully. However, my pregnancy created multiple health issues. I was told to stay on bed rest due to a subchronic hemorrhage, hematoma, which is bleeding that occurs when the placenta detaches from the uterus, which I learned after the fact is very common with surrogacy pregnancies. I suffered from intense morning sickness, preeclampsia, and the last few weeks of the pregnancy, I had to have blood infusions and sign paperwork that allowed them to do a blood infusion if I were unconscious and unable to make the choice at the time for myself. I was unable to do many normal things because of the health issues from the pregnancy, and my family had to step in and help pick up the pieces because I was unable to do so. The surrogacy took a toll on everyone in my home. The physical and mental side effects took their toll on me. Due to the preeclampsia, I had an emergency C-section at 37 weeks. The intended couple hired someone to be at the hospital to take care of the baby I just gave birth to. I did briefly meet the baby I carried. It was short, rushed, and extremely difficult. At the hospital, a nurse indicated that the circumstances were strange and disclosed to my then husband and I that the father had completed the baby's birth certificate with a different name from either of the intended parents. But with the trauma of the birth, the physical exhaustion and coming down off of morphine, I wasn't in an understanding state of mind, and I was very confused. 3 days later, after the birth, I became incredibly sad. I started crying over the loss of the baby. I missed him. You can prepare yourself all you want, or so you can say. The baby was never yours, but there was and still is a real feeling of separation. I bonded with him. I carried him, and I miss him still. That is something you can't prepare yourself for. 3 months after I had the baby, the agency was already asking if I would carry another. In 2020, roughly 8 months after the birth, I was contacted by lawyers asking for my assistance in executing an adoption order so that the baby could be adopted by his actual father, who was the sperm donor. I was very confused. It turns out the baby was taken from me by the so-called intended parents and their nanny to England, where the baby was put up for adoption to the baby's sperm donor, who I thought was the man that I had met. Unfortunately, that wasn't the truth. This was the plan all along. The intended couple that I was carrying the baby for was actually an employee of the sperm donor. And it was this man and his partner who were trying to now adopt the baby that I carried. In England, the law states that whoever birthed the baby is the biological mother up until 6 months. So I was this child's mother, and this child was with fake intended parents. I traveled to England, and this child was taken and traveled to England with a nanny hired by the fake intended parents and finally ended up in British foster care. I ended up getting... I'm so sorry. Okay, I'm going to reread that last bit. In England, the law states that whoever birthed the baby is the baby's biological mother, and they cannot sign over rights until the baby is 6 months old. So I was this child's mother, and this child was with fake intended parents, and he traveled to England with a nanny hired by the fake intended parents, and finally ended up in British foster care. I ended up getting an attorney in the UK who explained all of what was really happening. I had traveled back and forth to England for court proceedings. Ultimately, the courts in England allowed the baby to be adopted by the genetic father and his partner. The reality of what had happened created major mental health issues. At this point, I began seeing a doctor. I was asking myself, what in the hell did I just do? This is the question that's going on, and I'm asking myself every minute, every day for months. You just gave this baby a messy life. This process has far-reaching consequences, not just for me, but now for this child that I carried. I'm now divorced. I suffer profound anxiety and have been left to pay for expenses resulting from the mess that was created with this deceptive practice. If I could go back and redo this all over again, I never would have done this. It ruined my life and likely that baby's life as well. I hope this story will highlight to all of you how the lack of laws and legal protections are placing women like me and the babies we carried at profound risk. I hope that Texas takes the initiative. I know you guys are the Lone Star State, but let's make it all 50 states and let's start the movement here. Thank you. God bless America and God bless Texas.
We'll ask some questions. I was trying to follow all of that and how that went, but we'll go through the whole panel and then come back to you. Thank you for testimony. Ms. Law, if you would pull it very closely.
Happy to.
Thank you.
Chair Colkhurst and Vice Chair Perry and members of the Committee of Health and Human Services, thank you for the opportunity to testify before you today. My name is Jennifer Law. I'm a registered nurse with a master's degree in bioethics and the founder of the Center for Bioethics and Culture Network. For over 20 years, our organization has researched, documented, and advocated against the exploitation inherent in the assisted reproductive technology industry, specifically surrogacy. We produced 2 documentary films such as Breeders, a subclass of women, ? And Big Fertility, that tell the real stories of American women and children harmed by these practices. We have published peer-reviewed research on the harms of gestational surrogate pregnancies. I have testified before legislative bodies all around the world and across this country on these issues. In fact, I testified at the United Nations in Geneva, Switzerland just this last week. While I was born in Texas, I now live in California, one of the most surrogate-friendly states in the country. California is considered a reproductive tourist destination for both domestic and international commercial surrogacy arrangements. Women's bodies are treated as commodities, and children are products to be bought and sold. Since most of Europe and Asia prohibits surrogacy, would-be parents travel to the U.S. And as you heard Senator Colkhurst mention, our Supreme Court just ruled guaranteeing that birthright citizenship. So every child born here in the United States is a U.S. citizen. Over 40% of our surrogate pregnancies in the state of California are for foreigners. Agencies explicitly market their services to global clients, offering them travel support, visa help, and turning their trip into a vacation. These concierge services guarantee high-quality medical care, legal protections for the purchasing parents, often at costs exceeding well over $100,000. International prohibitions on surrogacy have created this multi-billion-dollar global marketplace, a market targeting financially vulnerable young women, and the primary target here is our military wives for their wombs. My son serves in the U.S. Navy, so I, of course, am very keen to support our military. And a market for babies. Many European countries prohibit surrogacy because they recognize that the human body, motherhood, and the parent-child relationship should not be subjects of a contract or a transaction. Yet here in the United States, the contract is at the heart of the surrogacy industry. These contracts prioritize those paying for or profiting from the arrangement. They also regulate a surrogate's behavior, her ability to travel, important medical decisions, and even require compliance with selective reduction or termination clauses where they're permitted by law, which I know in Texas they are not. Financial penalties are tied to compliance. If the surrogate fails to obey, she's threatened with breach of contract, will have to return all the money she has received and more. If you've never read a surrogate contract, I encourage you to do so. I have many I can provide and share with you. French law effectively treats surrogacy as a form of prohibited commodification akin to exploitation or slavery-like practices. Surrogacy is such an undignified way to treat a woman and a child she carries. Our own research builds on the research of other studies which show gestational surrogate pregnancy is medically high risk, like you heard in Christian's testimony. As a pediatric nurse, I too know that when a pregnant mother is at risk, her unborn child is also at risk. What are these risks? Sorry. The risks are gestational hypertension, preeclampsia, placenta previa, C-sections, and long-term health consequences from the powerful hormones from IVF drugs. Surrogate mothers have died in the United States because of these high-risk pregnancies. The babies they've carried have died. Many report profound grief and trauma from relinquishing the baby they carried. In fact, surrogate mothers are more likely to have postpartum depression and be diagnosed with mental illness. For babies, they are deliberately separated from the only mother they have ever known, and they too have long-term health consequences due to higher rates of prematurity and low birth weights. Despite these realities, there are minimal guardrails, no meaningful limits on the number of child a woman can carry, may be contracted to carry over her lifetime, weak or non-existent requirements for long-term health tracking of surrogates or children, and virtually no oversight of this multi-billion-dollar agencies and the brokers who facilitate these deals. But all the regulation in the world will never protect women and children. I'm happy to speak at this hearing and support any legislation that might be an important start to protecting women and children here in the state of Texas. My recommendations would be close your borders, close all international surrogacy arrangements, whether they be commercial or altruistic, meaning the surrogate is just doing this for free. Monitor state agencies that market and broker these arrangements to be sure they are in compliance with the law, and establish a statewide tracking system of women who were surrogates and the children born of them to follow up on their long-term health and well-being. Members of the committee, pregnancy is not a service, it's not a job. A woman's womb is not a rental property, and a child is not a product to be bought and sold. Texas can and should lead by rejecting this form of 21st century exploitation and protect the dignity of women and children. Thank you.
Thank you. Ms. Doss. And if you would pull that microphone closer.
Thank you, Chair Colkhorst and Vice Chair Perry and members of the committee for the invitation to join you today. My name is Dr. Tara Das, and I'm the State Registrar for Vital Statistics at the Texas Department of State Health Services. I'm here today to present information on how surrogacy information is reported to the state as part of birth registration and filing birth certificates. Today, I will be focusing on birth registration requirements and process in Texas and gestational agreements. In the United States, the vital statistics system is a decentralized one with the responsibility for reporting and registration of births and deaths at the state level. All states send birth and death data to the CDC, Centers for Disease Control and Prevention, to their National Center for Health Statistics, or NCHS for short, by contract for compiling national vital statistics for the country. Within Texas, the responsibility for gestational agreements is at the hospital level. I will discuss this in more detail as we go through the slides. With birth registration, there are about 400,000 births reported each year in Texas for registration. And in Texas, the laws and rules for this state govern our state's vital statistics system, including reporting, registration, amendments, and issuance of birth and death certificates. On this slide, you see a citation to Texas Health and Safety Code, section 192.001, requires that each child born in the state must be registered. A certificate of birth must be filed within 5 days of the date of birth for every live birth in Texas, and it's filed electronically in our vital statistics system, which is called TexEver, or Texas Electronic Vital Events Registrar, and that is the Texas Vital Events Records Management System. By law, physicians, midwives, or person acting as a midwife in attendance at birth must file the birth certificate with the local registrar of the registration district where the birth occurs. And in TexEver, for electronic reporting, the local registrar and the state receive the record at the same time from the hospital or midwife. So statute designates the individuals who may file a birth certificate, and those authorized certifiers include physicians, midwives, hospitals or birthing center administrators, and designees of hospitals or birthing center administrators. And the certifiers are responsible to collect information from various sources to complete the facts of birth. And that includes the mother, the mother's physician, infant's physician, immediate family members, and medical records. So Texas laws and rules prescribe who may file a birth certificate and also specific data fields to include on the birth certificate. Per Health and Safety Code 192.002, the department shall prescribe the form and contents of the birth certificate. To promote national vital statistics and ensure there is a minimum set of data fields that all states collect, each state has a contract with the CDC, National Center for Health Statistics, and that is called the Vital Statistics Cooperative Program, or VSCP for short. Through this contract, additional data fields are required for all states, including risk factors in this pregnancy, such as fertility treatments, or characteristics of labor and delivery. The CDC also provides standard instructions and guidance for uniform data collection. This image on this slide depicts our birth worksheet. Birth registrars, including medical personnel, attendants, or birthing facilities, may complete it to help a birthing facility collect the necessary information for reporting births in TexEver. We instruct birth certifiers that they are responsible for the quality, accuracy, and completeness of the data they report. The data that they are reporting for birth registration is used for both legal records, for birth certificates, and for public health programs. And TexEver includes system edit and security checks to help with this. So in terms of the resources that we provide at DSHS, it's a birth worksheet, which is a voluntary data collection tool to assist with TexEver reporting, a birth registration handbook, a birth registrar certification course, and TexEver user guides. We also make available CDC guidance to ensure consistent instructions for vital statistics. So this slide depicts the steps for birth record reporting and issuance. So when a birth occurs in Texas, it is reported to DSHS in TexEver for registration as a vital record. Then it is available for issuance as a certified copy that is used for legal and administrative purposes as birth certificates. So in Texas, the baby is born. The birth certifier collects the necessary facts for registering the birth. It needs to be submitted in TexEver within 5 days of birth. We register the birth, and it is then available for issuance as certified copies of birth records. So when DSHS registers the birth, it is after the reporting facility or birth certifier has addressed all the system quality and security checks in TexEver. A TexEver user account also cannot be obtained until a fingerprint-based criminal background check has been cleared. So that is required of all birth certifiers. The responsibility of true and accurate reporting remains with the birth certifier, including reporting the record type for the birth. And the record types include being born at the facility, a foundling birth, a home birth, or a surrogacy birth. So gestational agreements. A gestational agreement is an agreement between a woman, per statute known as the gestational mother, and the intended parents of a child in which the woman relinquishes all rights as a parent of a child conceived by means of assisted reproduction, and that provides that the intended parents become the parents of the child. In Texas, surrogate births require a gestational agreement that must be validated by a court as outlined under Texas Family Code, Chapter 160. So as part of our training to birth certifiers, DSHS includes the following guidance: to please refer all gestational agreements to your legal department to verify the agreement is acceptable and in compliance with Texas statute. Once your facility has deemed the agreement acceptable, you will enter the information in TexEver. So with regards to gestational agreements and birth registration, birth certifiers are required to review the gestational agreement to determine whether it applies when registering a specific birth. The birth certifier should also review whether the agreement follows the requirements and procedures outlined in Texas Family Code, outlined in statute. Once the birth certifier determines a valid agreement is in place, the registrar selects that specific options within TexEver to complete the birth registration. And there is, as I mentioned, a specific record type for surrogacy. And the following slides walk through the TexEver registration process for surrogacy, so you have an idea of what the slides are that birth certifiers see. So in TexEver, once you've started a birth record case, you select on that, there are the tabs that are to my left, starting with newborn. Those are all the tabs that go down the line in terms of the information that needs to be provided. And those tabs will, additional tabs will enable based on the record type. So that record type is that highlighted drop down right there, and that's where you'd see the options for born at this facility or born en route to this facility, foundling birth, and surrogacy birth. So for surrogacy, we have two options: surrogacy one parent if there's only a single parent involved, or surrogacy two parent if there are two parents involved. And so if surrogacy two parent, for instance, is selected, you see additional tabs to my left display, and that is below newborn, mother, and mother demographics. There are two tabs that display it for intended mother and intended father. If the record type selected was only surrogacy one parent, then the tab for intended mother only would enable. So the information that we collect for intended mother and intended father are the fields that are going to print on the legal birth certificate. So we are collecting information for the surrogate mom on the mother tab, but for the purposes and in compliance with Texas Family Code, when the birth certifier has reviewed and knows that they have a validated gestational agreement in place, they pick the record type of surrogacy, then those additional tabs will enable in TexEver as part of reporting the birth. And then they are entering on these tabs for intended mother and intended father the information that's actually going to print on the legal birth certificate. And the legal birth certificate will not say if it's a surrogacy birth or not. It doesn't say what the record type is. And then intended father, the same applies. Thank you. Before I go into the surrogacy statistics, actually, sorry, can you go back one? Thank you. Yes, there are additional tabs. As I mentioned, each tab includes fields that are collected as part of birth reporting. You'll see tabs for mother medical and newborn medical. That includes information that doesn't print on the legal birth certificate, but is collected for public health purposes and is considered confidential. It's information such as risk factors in this pregnancy, infections present or treated during this pregnancy, and then congenital anomalies for the newborn, for instance. And I had mentioned that we also provide CDC guidance that is provided to all states for consistent and uniform reporting. And when there is a surrogacy birth involved, when that's the record type selected, the guidance that is provided to birthing facilities is that consider for those additional tabs for the mother medical, you would consider the mother as the woman who gave birth to or delivered the infant. So all birth certificate information reported for the mother should be for the woman who delivered the infant. In cases of surrogacy or gestational carrier, the information reported should be for the surrogate or the gestational carrier, that is the woman who delivered the infant. So that's the guidance that is provided at the national level, and we continue to disseminate that. And it's longstanding guidance. When I talked about there being a minimum data set that all states provide to the CDC for national vital statistics, it includes information on like fertility treatments, and so that's the guidance that we provide. And then here are some, based on that record type being selected as surrogacy one parent or surrogacy two parent, here are the counts over the last several years. Again, the denominator is that sort of 400,000 births per year that occurs in Texas. So on average, that's about 0.10% to 0.17% of all births in Texas have a record type classified as surrogacy one parent or surrogacy two parent. So thank you again for the opportunity to present today on surrogacy information. DSHS appreciates the opportunity to share this data with the committee, and I'm happy to answer any questions you may have.
Thank you, and we will. Steve Wallop?
Yes, good morning, Madam Chair and Mr. Vice Chair, Senators. I'm Steve Wallop with the Texas Hospital Association. I'm here on behalf of our over 460 hospital and hospital system members. It's a privilege to be able to be here before you today. We certainly thank you for the invitation to testify. I think my comments will be fairly brief because, hospitals are sort of at the end of this process. I understand from prior witnesses, certainly things can happen after delivery that that could sort of prolong this whole process. But in terms of sort of the formal, statutorily defined surrogacy process, hospitals are kind of obviously at the end when the birth occurs. And it is, in fact, oftentimes the first time that the hospital is even aware of a surrogacy arrangement is when the woman presents to deliver her baby in the hospital. So I'll give a little bit of additional background on Texas statutory scheme, with apologies to the actual family lawyers, which I'm not, that define how these surrogacy arrangements are supposed to operate, and then a little bit about what happens in the hospital when the woman comes in to deliver her baby. So as we've heard, Texas Family Code Chapter 160 sort of generally defines the parent-child relationship, and Subchapter I is where the gestational agreement and surrogacy framework is found. As we heard from Dr. Doss, the Department of State Health Services records all birth registrations in Texas through their vital registration system. And so hospitals look at both the statute in Subchapter I of Chapter 160 and Department of State Health Services instructions, which do follow the statute, to inform processes around the birth registration process, including gestational surrogacy. So Chapter 160 defines a process for entering into a gestational agreement for surrogacy. I believe that is required to be entered into at least 14 days prior to the transfer of the embryo to the surrogate mother. And then what happens is the agreement is required to be validated by a court. And I'm not sure that, I don't think the statute defines exactly what the time frame is for that. I think it can be done essentially any time before delivery. But you can check my math on that. But as long as the agreement is validated by a court, then the intended mother and father via the agreement are the parents of the child, and their names are to be placed on the birth certificate. So that's what happens in the hospital. In this scenario, the surrogate and her spouse, if she has one, would have relinquished their parental rights to the child via the gestational agreement, and when that gestational agreement was ultimately validated by a court. If there's no validated gestational agreement, and I use that term specifically, validated, you can have a gestational agreement and the mother comes into the hospital and delivers her baby. But if it's not validated by a court, then the parent-child relationship, to our knowledge, is determined as any other parent-child relationship under the family code, and that is that the woman who birthed the child, the surrogate, is the mother. If she's married to someone, the spouse is considered a man considered to be the presumed father of the child. If that happens, a surrogate mother comes in and delivers her baby without a validated gestational agreement in a hospital, then in terms of conferring parental rights on the intended parents, that would have to happen under other provisions and processes under the family code through a parental rights relinquishment and the adoption process. So we heard Dr. Doss talk about the birth registration process and their handbook and system providing instructions for completing birth certificates in the hospital, and an administrator or the administrator or their designee is the one who does that in lieu of, generally in lieu of the physician or the midwife. And then as I said, the guidance handbook echoes the family code as it relates to gestational agreements and surrogacy arrangements. So We will always look for the court order in the hospital when a surrogate mother comes in to deliver her baby. One of the questions we got before today was, can a hospital disregard a gestational agreement? And the real question is, can the hospital disregard an order validating a gestational agreement, I think? Because if you've got a gestational agreement that's not validated by a court order, we're not disregarding anything. We just can't honor it in any way. We would follow the law as it relates to parentage. And when we're filling out the birth certificate, as I said, include the birth mother's name on the birth certificate. If there is a court order, we will follow it. So that's generally, the process. It's a fairly, bright line rule for us. We're not, we certainly can't disregard a court order issued by a court of competent jurisdiction. So that's how that process works. Oftentimes, we will only be presented with a court order. Sometimes we will also be presented with the actual petition that was filed to validate the gestational agreement, which has the gestational agreement attached. But sometimes we don't even get that. We would go by what the court order says, and the court order generally, in these cases, directs hospitals to fill out to consider the intended parents to be the parents of the child and to fill out the birth certificate accordingly. So that's what I have in terms of our prepared remarks. Certainly, thank you again for the opportunity to be here today, and glad to answer any questions.
Okay, members, a couple of questions. Steve, medical professionals are mandatory reporters, right?
Yes, that's correct.
Okay. So
Of child abuse and neglect.
you're right.
Yes.
And so, exactly, in Texas, they are required to report suspect abuse, neglect, and exploitation. I have a question. Commissioner, would you state your name for the record and who you're with?
Sure. Audrey O'Neill, Commissioner at the Texas Department of Family and Protective Services.
In this whole regard, and there's lots of questions, and so thank you all for your presentations. Has DFPS received reports of abuse, neglect, or exploitation related to surrogacy cases in Texas?
We have a very small number, and for first caveat is that Impact, our case management system, does not track these independently. They're pretty rare, so it's easy for us to have a pretty good handle on what they are. We've received 3 abuse and neglect allegations since about May of 2025. So it's a relatively small number, but we do have some.
And recent?
Yes, we received, I think, 2 in May of 2025 and 1 in November of 2025.
Without divulging too much, explain those cases. And it was surrogacy specific, as you say.
Yes, all 3 of these were surrogacy specific, and in all 3, there was some kind of concern with the intended parents. In 2 of the 3 cases, the intended parents were foreign nationals who did not reside in the United States. And in the 3rd case, it was an American citizen, a non-Texas resident, but an American citizen with a serious history of child abuse. And all 3 were...
The surrogate mother was?
No, the intended parent
The
was.
intent... So let me make sure I just wrap in mind. This is like a lot to wrap our brains around. So on 2 of the 3 cases, 2 were about foreign nationals, correct?
Correct.
And the surrogate was not a U.S. citizen. Or the donor.
Gestational mother, the surrogate mother, I believe was U.S. citizen in all 3 cases.
Okay.
It was the intended parents. So I believe the biological father, and I'm not sure about the mother, were all non-Texas residents, and in 2 cases they were foreign nationals.
And the mandatory reporters, was that at the hospital level or was that at?
They were all medical reporters, yes.
Okay. Interesting. I want to go back to Ms. Ross for a second. I was trying to follow your story there, so I'm just going to ask a couple of specific questions. Did, when you volunteered as a surrogate, and I'm sorry if this gets too personal, I don't want to cross a line.
No, that's what I'm here for, to be transparent.
Okay. So you had how many children of your own? Two?
I have 3 children on my own, yes.
And you stated in your testimony that you wanted to do something, you felt compelled to do this. Were you paid as a surrogate?
Yes, I was.
Okay. Could you divulge how much that was? Is that crossing a line?
No, not at all. I was paid about $40,000 to carry the baby to term. And then, as an incentive, whenever I had my C-section, they gave me an additional $2,500.
What was the incentive of the 2,500?
Because my body had to be broken open, and I had never had a C-section before. So it was just kind of like a clause in a contract that if I were to have a C-section, they would give me an additional amount of money, which was $2,500.
So this agency that you contracted with was out of
California?
California, and I'm just, again, I don't want to
No.
go over a line here, but so you contacted them, kind of like, how do you find, like, I know there are billboards out there now.
Oh, yeah.
And I will say that, you know, I've kind of, for those of you that know me, I have this billboard rule when it comes to health and human services. The free braces of what we went through and the scandal that we went through with free braces. I've now been shown billboards of want to earn extra money, be a surrogate. And it again, so I that crosses a line for me.
Yes.
But I'm trying to be very sensitive here. So how would you find someone like this? Did you see a billboard?
No. Actually, I had lots of friends that were struggling with infertility at the time, and I had offered to help. Unfortunately, they weren't able to, afford it. However, 2 out of the 5 couples actually got pregnant on their own, which was fantastic. But I still felt compelled that there were other people out there that couldn't have children naturally. And I was very empathetic to that. So I just did a basic Google search of surrogacy just as a whole. And if you do that, you're going to have agencies that pop up from here to there. And I just did a little bit of a little bit of a profile with the one agency that I did go with. And they had contacted me the very next day and was ready to start the process.
And so just you were offered, you started the process.
Yes.
Did you know there would be $40,000 is pretty big money. Did you know that was going to be the case?
Not at the time. So the way it worked out is that they would give me monthly payments out of the $40,000.
They would what? I'm sorry.
They gave me monthly payments.
Okay.
So out of the 40, it wasn't like a lump sum at the end. It was like monthly payments that helped me pay my bills at the time. I was raising 3 children, one with a type 1 diabetes and autism. And it was a way for me to help people and a way for me to be at home with my children. However, that wasn't the case. Everything that I got from the money, I had given away. I bought a brand new car with it, or a new to me car, gave it away, because after I found out the fact of what had happened, it seems like dirty money, and I wanted nothing to do with it.
So I'm going to go down this rabbit trail again. I'm just learning here.
Yeah, absolutely.
And I'll do some Googling tonight, so
Yeah.
thank you. I could Google and say,
You
I want to
can
be a surrogate.
Just, even if you just type surrogacy into a Google search right on your phone, you're going to have agencies that pop up.
In your testimony, you knew that this was going to be foreign parents. Is that correct?
I did know. I had been told that they had 1 child and wanted to expand their family. However, they weren't able to have children naturally anymore.
You made a statement that you found out later that the egg donor was also pregnant at the time.
Not
no?
the egg donor, the intended mother. They had an egg donor. We don't know who that is.
Okay.
So the baby's mother, biological, nobody knows who she is. But I had been told by the surrogacy agency, mom could not carry children naturally on her own anymore. And I had known about the one child rule in China, and that's what I was told they had was one child. And I felt bad because now that they got out of their country and they could expand their family, now they weren't able to. And I felt compelled to.
So one more question. If you got paid $40,000,
Yes.
these companies, I'm going to call them surrogacy companies. I don't know. What are they?
They call themselves agencies.
Agencies. Surrogate agencies?
Yes.
Again, I'm, like
Yeah.
wide-eyed here.
Yes.
How much are they getting paid?
A lot. After I had already had the embryo transfer, I had learned that they were a VIP couple, which I still don't understand that, other than I believe that they paid close to $500,000 overall.
The IP couple, what does that mean to us?
Intended parents.
Intended parents.
The parents that had that I was told I was going to carry for.
Paid over $500,000.
Yes. However,
Follow-up
it
question.
wasn't them.
Did the surrogacy agency in California provide you with any legal representation through this process, or were you on your own to do that?
They did provide me with a legal team. However,
So they're paying you, and they make you sign a contract, and they get the lawyers
yes,
to
yes,
represent you.
Yes. So there really aren't in a surrogate's best interest, as I learned after I had the baby.
Okay, and then I don't know what your contract said, but is there any repercussion for them lying to you?
There was. However, did get lawyers or tried to hire lawyers in California, and the surrogacy industry is very tight knit in California. They all knew each other. They called me a liar. And the one agency that actually kind of maybe I thought took me a little seriously had told me that we could put this aside and they could assist me with having another surrogate baby. And that was their answer to me for the fraud. Well, let's just have another baby. It felt really odd, and they wore me out of the time frame that I could do legal repercussions. That they could face legal repercussions. I think it's about 2 years, 2 or 3 years, and the lawyers had me on the hook. Yeah, we're going to do this, we're going to do that, and then they're like, "Oh, we timed out." So.
And did your medical bills? Who paid your medical bills?
I had had insurance for myself through my ex-husband's work. So a lot of that was paid by them, but the other things, the intended couple had to pay the medical cost as well.
Ms. Lowell, I'm going to ask you a couple of follow-up questions. Are there any limitations for international parents to pursue surrogacy in the United States?
No. I will, with two caveats. Recently, Prime Minister Meloni in Italy and Slovakia changed their constitution to close the loophole for travel, because you can't do surrogacy in Italy or Slovakia. And now they've changed the law, so you cannot leave Italy or Slovakia, come to the United States and have a surrogate baby and bring that baby back. And there's penalties attached to couples that do that. So they're closing the tourism loophole. Otherwise, there's no limitations.
And are you aware of agencies in Texas that are openly advertising to foreigners in China or any other country and how they come here to pursue surrogacy?
I didn't research that. I mean, I want to say I would be surprised if there are not agencies here in Texas that are, opening up the doors and saying, come here, we'll help you get a baby. But I can't, give you names of agencies. But I would probably bet you lunch that they exist.
I'm going to ask this question openly. Is there any registration of surrogacy companies in the state of Texas? Is Health and Human Services here? Can you come forward? I'll have you switch out, with Commissioner O'Neill.
Okay.
If you would, state your name for the record and who you're with.
Yes, David Costrin with HHSC.
Surrogacy agencies, is there any registration? Is there any licensing? Is there?
No, they're not required to be licensed. They're not regulated by HHSC. We just regulate facilities, healthcare facilities. Some could perform the fertility, but those facilities are not licensed or regulated by HHSC.
So are adoption agencies registered, or can you come forward, Miss O'Neill? I'm sorry, we're going to play musical chairs here.
Audrey O'Neill with DFPS. Yes, there is some regulation of adoption agencies. I might have to punt for some help on the specifics, but there is at least some level of registration. For sure, if it is a foster to adopt situation, those are all regulated by HHSC. I'm less certain of straight adopt entities. We can follow up with an answer.
Okay, I'm going to go back to Ms. Law. What are other states doing in this regard?
They're not regulated. They're like small businesses. I mean, who's regulated is lawyers have to follow, the Bar Association laws for contracts. Fertility doctors have to follow whatever the guidance is for medical practice within the state. But the agencies literally are like mom and pop shops where you just, register an LLC or a small business and you have a name and you hang out a shingle and you just start matching people.
So who verifies what surrogacy agencies are telling people? I mean, like,
There's no standard.
There's no standard.
There's no contract standard.
All right, now, I'm
I'm
get down
even
in the
curious
weeds
after
here.
hearing Dr. Doss's presentation, do vital records, birth certificates record an egg and a sperm donor? Because they're part of this equation and they're important parts of the medical history of, did your mother have diabetes? I don't know. She was an egg donor. So it's like throwing spaghetti on the wall and whatever sticks.
And law in Texas follows the best interest of the child. So I'm just going to ask this question. You were recruited, okay? Yes. You were recruited. And again, I'm going to be very
go
sensitive
ahead.
here. I'm so
No,
sorry.
you were okay.
You sign a contract. We go through all this legal, and then, I'm just going to ask this question. Like, a fertilized egg is implanted in you, correct?
Yes,
Who did that?
a doctor.
Is it the doctor of the surrogacy, or do you get to pick the doctor?
I did not get to pick the doctor. The doctor was assigned to me because that's where the embryos were being held, was in his office through the intended parents.
So this is a whole one-stop shop.
Yes, it is. Yes, and it's very convenient. And as you said, $40,000 was quite a lot of money. The incentive now is for first-time surrogates to be, I believe, $100,000 through the agency that I used. That's what they're paying surrogates now.
You did not get to pick your doctor.
I did not.
I
I did get to pick my doctor for my care in my home state,
Okay, and your home state is?
Pennsylvania.
But you went to California to be.
Yeah, they had an office in Wheeling, West Virginia, which was very close to me, and that's where I was supposed to just stay East Coast, but then all of a sudden I had to go to the West Coast to have these procedures. So it was a little, you get told one thing, and then another thing kind of evolves. So, and you're kind of locked into a contract and bullied with that if you don't do everything we say, you have to do this. You're going to pay back every single penny that we've paid you up until this point, and then there's going to be repercussions on top of that.
And then I'm going to ask Ms. Law this question. Does anything in federal law or any state that you know prohibit foreign couples from seeking out American surrogates?
No. No, nothing in federal law.
So just, again, as I described in my opening remarks, I woke up in the country this morning, okay? Literally.
Lovely.
So, like, you can be over there, you can name the country, the UK, China, you could be in, I don't know, Afghanistan, you could be anywhere, right? And you could contact this company, or I can Google tonight any company, and say, I want an American surrogate. Yes?
Yes. And you can say, I want a Danish sperm, and they'll freeze sperm from Denmark because you love how Danish men look. And you can say, I want an egg donor from Colombia because I want a smart, Ivy League egg donor. I mean, it's just, it's like Legos. I want this and I want that, and I'm going to build this kind of baby.
Okay, so stay with me, because I kind of always looked at surrogacy as a person who couldn't have a child, and maybe, pre-cancer, before they had to go through cancer treatment, the young female might have frozen her eggs. And like, I never dreamed that we're just, like you said, building a Lego. I want an egg from this ethnicity because I like this, and I want a sperm from this ethnicity, and we're going to merge it, and we're going to go rent a womb. Is that happening?
And we'll take a low-income woman or a military wife, because we don't care if she's smart and pretty. We mostly care that she needs money.
All right, now I want to segue, and then I'm going to go to all these questions. Dr. Doss, I tried to, you're great. You're a statistician. On the birth certificate, let's take this foreign, let's just say a UK citizen. We'll use a UK citizen, and they decide that they want to have a US citizen, right? So we're going to go through this surrogacy agency that is not registered. We'll just make it in Texas. We'll leave California to itself. We had a lot of discussion about California and their mistakes yesterday. We're going to say they're going to find a Texas surrogacy agency, and they get, and I'm going to ask Ms. Law this question, the egg could have come from anywhere, like you're saying, right?
Ship beautifully. Freeze and ship nicely.
And the sperm can come from anywhere. They're united in a petri dish, right? And then they're implanted in a Texas woman. Let's just say this. They go through, and I'm sure the surrogacy agencies here in Texas probably have the one-stop shop like you're describing. I don't know. They go to a Texas hospital. They give birth. They are now a Texas citizen, correct? And they were born in Texas, so they're going to have a Texas birth certificate, and they are a U.S. citizen, correct?
They have a Texas birth certificate. Yes.
Great answer.
Yes.
Okay.
I don't determine citizenship.
That is a United States citizen.
Yeah.
Then after that, the hospital, Steve, they give birth. How long did you have your baby?
After?
How many? Was it hours?
No, minutes.
You saw your baby that you carried for 40 weeks.
37 weeks, yes.
37 weeks, that's right. You gave birth at 37 minutes. Then they go into your nursery. Let's say it's a healthy baby. And then they're taken away. So I'm going to go to Miss Law because you seem to have studied this a lot. They're taken away to where? We're gone. We're going back to the United Kingdom. correct?
So, because you shouldn't put a brand new newborn baby on a plane, an international flight. So oftentimes they're put in some kind of temporary housing, not with the surrogate mother. A lot of times the intended parents aren't here. It's not uncommon for couples in China, to send somebody or pay somebody to pick up and bring the baby to China. They don't even come. But so in that period of time until the pediatrician or whoever has said, yes, this baby is safe to travel now on a 14-hour international flight, they go somewhere. And that could be, a lot of times these fertility agencies will have arrangements with women that they pay to care for that child, if the intended parents haven't come and are staying in a hotel or whatever. But it's not like the baby can instantly hop on an international flight. And again, it's not standardized for where this child is kept for those early days or weeks. It's just, a lot of times it's the agency themselves that has their own staff that are watching these children. Similar to what we found in Arcadia, California, with that home that had 20-some children that were just being kept there. They were probably waiting for whoever could clear them to travel and go back home where they were supposed to end up.
I'm just looking at our penal code, sale or purchase of a child. I think we're really close. I'm having a hard time, especially when we're doing the Lego thing. And I have to really wonder, are we selling and purchasing children at this point? Now, and again, I'm very careful about this because I know, people that are infertile, like the friends that you started with, and 2 of the 5 ended up having children. How beautiful is that? But there were 3 that weren't, and that didn't. And so how do we, I mean, this is the question, like, this is one of the biggest questions. Where are the bioethics in this?
Well, and people will say, well, we're not buying a child, we're not selling a child. But again, you read that contract, the compliance is tied to delivering and handing over, relinquishing a child. And if you don't do that, then you are in breach of your contract. So I don't understand how anybody could read that and with a straight face and say, money has no bearing on this
Ms. Ross
transaction.
could get paid $100,000 now instead of the $40,000, correct?
Correct, if I didn't have complications after this birth that caused me to not be able to have children anymore.
You can't have any more children.
I cannot have children anymore.
And then, before I go to the members, you mentioned that you were contacted how quickly?
3 months. That didn't stop there. My lawyers that they had hired for me had also asked me to carry again. Several lawyers that I contacted for help in California had also asked me to carry. It's very loose ethics, as you had asked about the ethics around it. And as she said, babies are made with a certain sperm. They're graded, just like eggs. So embryos are graded A, B, C, D, meaning A's the best, D's kind of like the low end, and that's when they'll put a few of them into a woman and see what will take. But we do have an issue of people designing their babies now, and I don't think that is family. I after learning and going through this entire process, it's just a really kind of gross practice. And there are so many kids in foster care. Why can't we just, why?
I'm going to start on this end of the dais and work around Senator Hughes.
And thank you, Madam Chair. I thank each of our witnesses for helping us understand what's going on. Dr. Doss, I have a couple of questions about your presentation. Thank you. It was many of the questions that I was writing down as you were testifying, you answered in due course. I won't have to go back through those. Thank you. This question is for you. This threshold question is for you and anybody on the panel. My understanding of the Texas law, the current Texas law, is that the intended parents, and I'm going to use the term intended parents, meaning the folks who are
Taking the baby.
who are going to have the baby, right? So the intended parents, I understand Texas law requires them to be married. Is that anybody know if that's right?
I think that's
Yeah, there's This gets a little bit complicated. The statute does say that the intended parents must be married. Now, so if you've got, so one way to read that is you have to have two people and they have to be married. Another way to read it is if there is more than one intended parent, they must be married. So it doesn't necessarily preclude a single person from being an intended parent, but the statute does say the intended parents must be married. So if you've got two people who are supposed to be the intended parents and they're not married, you can't consider them to be intended parents. But if you do have two people who are intended to be the intended parents, they must be married, and then they're considered to be the intended parents.
Okay, thank you. And I guess this was passed in 03. I don't remember a lot of discussion about what the intent was, but thank you, Steve. You teed up my question. So, Dr. Doss, you talked about sometimes there's one intended parent, sometimes there's two intended parents. Will you help us understand that? And as you prepare to answer that question, let me ask you a couple of procedural, I think that's the term, threshold questions. So for purposes of this discussion, for purposes of gestational agreements, we are always talking about a situation where the egg comes from one of the intended parents or a donor. The egg is not coming from the surrogate mother. Is that correct?
That's correct under the statute.
Okay, and that's the situations we're describing here. There are situations historically, and maybe even today, where someone might enter into an agreement with a mom, and that surrogate mom in that case would be her egg as well. But those are not covered by the Texas Gestational Agreements Act. Those are really not enforceable, I don't think either. So, is that your understanding?
I don't think they would be enforceable as a gestational agreement under this process, under subchapter I. I suppose what would happen in that case is you would go through the relinquishment and adoption process.
Right. Okay, so then for our purposes of the Texas law on gestational agreements, what we're talking about that are being taken advantage of, help us understand the one intended parent versus the two intended parent. A couple of things. How is one more common than the other? Are the procedures any different? You mentioned how the data is collected, and that was very helpful. But you see what I'm asking, Madam Chair? I want to understand that. How is it normally a married couple? I certainly think that's the intent of the statute, just based on reading it. But help us understand that. Just what current practice is under Texas law, as you understand it.
Mm-hmm. Yes, the surrogacy one-parent record type is to be used when it's a single intended parent, so unmarried. And then the surrogacy two parents is when there's a set of intended parents. And again, DSHS is not involved in the process, but as Mr. Waleb was saying, is that they're to be married per statute. And to your question about the statistics,
I realize that your agency isn't saying this is good or bad. I'm just asking you what the numbers are. I'm not fussing at you. I just want to know what the numbers are. So thank you.
No worries.
Go ahead. Thank you.
Yeah, it's funny. We have the numbers, but we're really not involved in the process.
No, that's important.
Yeah, with the breakdown of the surrogacy one-parent versus two-parent record types, the surrogacy two-parent is much more common.
Do you have just a ballpark for? I'm not trying to put you on this. I guess I am putting you on the spot, but do you have if it's in your presentation, we can look it up. But
okay,
or if you can get that for us, that's fine. I'm just curious. I'd like to know how many.
Sir Hughes, can I help you with? I'm gonna go down this line because I intended, Dr. Doss, if you'd go to page 15 of your presentation, and this is maybe to get to your heart. I see surrogacy one parent, and that line, and then I see surrogacy two-parent, and I didn't understand the difference between those two, which I think might be going to your question, but it might not be.
That's what I want to understand. Yes, Madam Chair.
I don't understand this chart.
So it looks like
answer his question and then explain this chart to me because I don't understand it.
Yeah.
So it looks like
I'm just pulling up a calculator so I can get you the.
Oh no, that's okay.
Dr. Doss.
Thank you.
That's statistician.
The expert here has handed me one of your slides too. It looks like there are a lot more.
There are. So it's
two-parent.
Right, so if we're looking at, I'm going to just do a full year because 2026 is half a year. So for full year, the 550 over the 657 is 84%. 84% are surrogacy two-parent. And then really the distinction for us for surrogacy one-parent versus surrogacy two-parent is really just if the intended parent, the one who's leaving with the child, it's a single parent, or if it's a married couple. And so when in text ever if you pick the record type as surrogacy one parent, only the tab in those screenshots, only the tab for the intended mother will be an additional tab to display, so that on the birth certificate, when that's issued, it'll just show a name of one intended parent. Versus if you pick surrogacy two parent as the record type, all it is that it's two tabs, and then you're entering information for intended mom and intended dad, and then that's considered the mom and the dad on the birth certificate.
Okay, thank you for that. You also shared with us in terms of record keeping and that sort of thing that there's certain information on the birth certificate, which should, in this case, if everything goes as intended, the names of the intended parents would be on the birth certificate. But then behind that, there's some confidential information that you have, and I want to get a little bit more information about that. So we were talking about complications in the birth, or maybe genetic information. Help us understand that. Do we know, does the agency know, or does the person at the hospital reporting, giving this information, do they know, forgive me, whether the egg came from the intended parent or whether it was donated by someone else?
That I do not know if the hospital knows, because we do not collect that level of detail in TexEver.
Madam Chair, may I ask Steve about that? Steve, any way for y'all to know that? Tell us about, if for that matter, not just the egg, but the sperm as well. Do we know whether the intended parents, one or both of them, are the donors, or whether maybe someone else is involved? I'm just curious. I don't know the answer.
Sure, and if that information is contained in the gestational agreement itself, and we receive a copy of the gestational agreement, that would be the only way we would know. As I said, it may not, that level of detail may not be contained in the gestational agreement, one, or two, we may not get a copy of it. We may only be presented with the order validating the agreement.
And so if you get the order from the court validating the agreement, that gives you the green light to submit the intended parents as the names on the birth certificate, right? So
That's
far,
correct.
so good?
Correct, yes.
Okay. And then, so if you just have that validation, maybe a court order or something signed by the judge, and you haven't seen the agreement, so then you wouldn't know whether the sperm or the egg came from the intended parents, or one or both or either. I think you just said that, but did I get that right?
Yes, correct.
If you do have that information in the gestational agreement, or otherwise you have it, when you're submitting the data on this portal through the Department of State Health Services, do you include all that? If you know, do your hospitals include that?
I can't answer that. I don't know if Dr. Doss can tell us whether there's even a field for that or not.
Well,
I don't know.
No, that's fine. Thanks. And I asked because as I was listening to Dr. Doss's testimony, she talked about whether the data is being collected on the intended parent, or maybe the surrogate mother, or help us understand that. Okay.
So as part of reporting a birth for registration, there is a lot of information that's collected, and
Yes,
only
ma'am.
a portion of that is contained as part of the legal birth certificate that someone, when they order a copy of the birth certificate, has. There's also a lot of medical and statistical information that's collected on the mom, and for the purposes of the birth reporting, that information is collected on the surrogate, the woman who delivered the infant.
Okay. So there's never a situation where the donor of the egg or the donor of the sperm in that case, so their information is not going to be.
Correct.
It's going to be okay. It's going to be the woman who.
Not going to be what?
It's not going to be in the state statistics on genetic information or health history. None of that stuff's going to be in the data you collect. Am I correct?
Correct. Yes.
Okay. So, but you will be collecting that data privately. Let me back up. You collect this data and it's reported as far as the whole population goes, but I can't look up Mrs. Smith, Mr. Smith has this condition, but you report it in terms of public health from population, anonymized. Does that make sense?
Yes.
Okay.
That's correct.
That data will be, in the case of the mom, it'll be about the surrogate the mom who delivered the baby, not the intended parents, whether they are the donors or not. Did I get that? Was a terrible question, but did I
No.
get that right?
You got that right, yes.
Okay. And to give us an idea of what kind of information that is, just if you don't mind.
I don't mind, and we can certainly make our worksheet available too, and we have that available as a data collection tool. But it's information, like for instance, on the mom, it'll be risk factors in this pregnancy, like was there gestational diabetes? There is a question on, as part of risk factors in this pregnancy resulted from infertility treatment. Exposures or infections present or treated during the pregnancy, method of labor and delivery, was there prenatal care, the source of prenatal care, pregnancy history.
Okay, so most of that is about the pregnancy itself.
Yes.
So that would sound appropriate to be reporting the data on the mom who was carrying the baby. Is that right?
Correct.
Okay. Thank you. That's the questions I had for now. It just helps us understand the process. And I'll ask one more question about the Texas law. As I read Texas law, there's a requirement that either the mother carrying the baby, the surrogate mother carrying the baby, or one of the intended parents be a Texas resident for at least 90 days prior. Is that get that right, Steve?
Yes, sir, and I'm having a hard time. Here it is. Right, under Section 16755B1, the prospective gestational mother or the intended parents have resided in this state for the 90 days preceding the date the proceeding is commenced. So that's the proceeding to validate the agreement.
Okay, so then to underscore what the chair was putting together for us earlier, in Texas under current law, and the Texas statute is stronger than most. It sounds like certainly stronger than California, but even under Texas law today, just so the surrogate mother was a Texas resident, both parents could be from anywhere and wouldn't even have to ever set foot in Texas, would they, under current
Correct.
law?
That's the way I read the statute.
Okay. Thank you, Madam Chair.
Are there surrogates without agreements? Yes, ma'am.
I guess I could take a stab at that, and I think that may go back to one of the scenarios Senator Hughes was talking about, where you have a sort of an informal surrogacy, maybe a sperm donor and a surrogate mother using her own egg, for example. Possibly those are covered by some sort of contractual arrangement between those parties, but they wouldn't fall under this Texas statute, so they couldn't be validated as a gestational agreement, and a hospital or a doctor could not list some other person as the parent of the child other than that birth mother. It would be an informal arrangement. They would have to go through that parental right relinquishment process and the adoption process.
And so at that point, the mother listed would be the birth mother.
The birth mother, yes, ma'am.
And we're going to come back to this chart because you're going to explain that to me.
Madam
Senator
Chair, may I-
Perry, and we're going to keep
Thank you.
working our way around.
Madam Chair, to your, may I say one more thing about the point you raised, if you don't mind, Mr. Chairman? And thank you. I thank you for underscoring that because, again, if a gestational agreement, following the Texas statutes, what we're talking about, but one of those informal arrangements. So when you said if it's an informal arrangement, not a gestational agreement, and the surrogate mother has agreed to do this, maybe through a contract, through an agreement with the intended parents, in that case, you underscored to us that in that case, without this gestational agreement blessed by a court, then the hospital would be required to list the birth mother, the surrogate mother, as the mother. And just so we're clear, that surrogate mother would be the mother for all legal purposes. Is that right?
Correct.
And
I
so-
mean, from our standpoint, during the hospitalization, obviously, and then everything else that happens after that until she relinquishes parental rights.
And so, and her relinquishment of parental rights would be not automatic. She may have a contract with that couple, but that doesn't mean a thing. The relinquishment of parental rights is a legal proceeding, right, that a family court would look at, best interests of the child. Unless she voluntarily gave up those rights after that, it'd be a very different situation. Is that right?
That's my understanding, yes.
Thank you. I want to make sure I get that too, Madam Chair. Thank you.
Ms. Ross, when you were implanted with the fertilized egg, was that in a hospital setting?
No. It was just in a doctor's office.
Do you know if this is done in a hospital setting, Steve, or?
I don't know. I don't think it's common for assisted reproduction to occur in hospitals, but I could get back with you on that.
Senator Perry?
Speaking to the IVF process, it's usually done at the doctor's office. There's a bigger conversation on that, and we aren't talking about that today, but I have 3 grandkids. So when I have a party talking about that process, I get a little sensitive to it because they're great. But on this issue specifically, let me just from a layman's perspective and not a biologist and not an attorney. And I think there's a whole lot of legal conversation in this. First of all, it is basically, is this a fair statement? First of all, there's a private surrogacy and then there's the agency-driven surrogacy. Fair statement. Is it fair to say that the private, I have a friend that wants to help us out as a baby carrier, whatever, those are probably not really regulated, to your point, that not having that formal gestational agreement, you've created some legal conversations post-delivery for sure. But generally speaking, those privates are not in this conversation today. Is that a fair statement, Ms. Law? Is it?
Yeah.
And that's kind of, I think, how traditionally this started, right? I think there was just people that were just helping out, and didn't need agencies' involvement and stuff. So with an agency involvement, and maybe, again, probably you're the best source of this, it was kind of intended there would be almost a transparent type relationship because you, I think, Ms. Ross, thought you were talking to the intended parent all along. Fair statement?
Fair statement.
So you thought you were talking to the parents-to-be. You said that was a lie, and I don't know if the contracts reflected this is your intended parent conversation. I guess it did. Okay. So they just were in complete violation. They're fraud.
Absolutely.
On the inception.
Yes.
In Texas, I assume contracts at the agency level, these agreements, would have the same provisions that mother, the surrogate mom, would be thinking they're talking to the intended parent.
I don't think it's fair to assume that.
Okay.
Again, because the contracts are not standardized.
Okay.
And you can basically,
So in Texas, that may or may not be the case,
Right.
and there may, and it's, I don't know that it's important for a relationship. I would think that a surrogate mom would know that she's handing the ball off, so to speak, to qualified, competent, good people, whether you meet them in person or not. So that was kind of the intent, I think, all along, is there was this transfer, if you will, to people that you're familiar with at least, or have had a background check or some process in which you're not handing them off to people that are going into slave labor. Or et cetera. So this guy that took the, yes, sir.
Oh,
Go
if
ahead.
I may just, the language in the statute does require the intended parents to be a party to the agreement, but doesn't necessarily require that other level of interaction that you're talking
Okay,
about.
all right. Party to the agreement and interaction. I don't know. I think that's a personal surrogate mom provision if she wants to know or meet. Maybe I don't know. What's your opinion? Are these foreign looking for the citizenship, or are they more motivated for the kid?
I think it depends on the country they're coming from. I spoke to a journalist in the Netherlands a week or two ago, and she basically said people from the Netherlands come here. They're not coming here because of U.S. citizenship. They're coming here because they can't do surrogacy in the Netherlands. Whereas I think China, Asian countries are motivated by U.S. citizenship.
So it's interesting. Everybody that hates America, so to speak, inside America, everybody's running here to get there for the citizenship badge. I think the irony in that. But so it would be your opinion it's mixed bag. There are some parents that truly need
Yeah,
kids.
correct.
And then there are those that probably look to, and I would agree with you. I think the Chinese probably look to that citizenship. We have no regulations over these agencies. It was confirmed a while ago by a commissioner. There's no background checks of these IPs, I would assume, in most states. I mean, if they can write the check, it doesn't matter what the quality or character or integrity of that couple is, they get a baby. That's pretty much Wild Wild West, right? I don't know how attorneys reconcile what law. You were from Pennsylvania, dealing with California, and having procedures done in West Virginia.
No, I had procedures done in California.
In California. I don't have any idea who's jurisdictionally over these contracts and the whole network that creates.
California.
California.
Yes.
the agency's agreement dictates, because in there it said you'll be subject to California law, I guess.
Correct, yes.
Wow. Yes, ma'am.
Sorry. I spoke with and interviewed a OBGYN doctor in South Dakota who was caring for a gestational surrogate who was caring for a couple in Spain. She was carrying twins. And the pregnancy, like Christian's, got very complicated, and she ended up having to have an emergency C-section. And he talked about just a conflict he had, because who do I serve? Who do I work for?
Right.
And I've got these intended parents in Spain saying, I want you to do X, Y, and Z. And he's looking at a woman in his office who's literally life and death, as are the twins she's carrying. So, the protections, even from not just, the agency side, is doctors are conflicted. Who do I, whose
If you have a
orders do I
Texas
follow?
medical license and you have a question about a particular procedure in California, medical licenses are dictating that. Texas license, he's going to lose his license if he doesn't do it the way they Texas want. I mean, I get that this is a mess. Madam Chair, I'm going to leave it pretty much. We're really meddling in stuff here. There's a part of me that we have a foster care system and an adoption network that parents that truly can't physically conceive. If it's not the old traditional surrogate, maybe we don't want to encourage birthright citizenship and tourism and create a network of American citizens that we don't even know. One question I had for you, Ms. Ross, let's say that the baby's taken a few minutes after birth,
Correct.
and it's taken to a holding facility until they're able to travel,
Correct.
and that baby were to die, or that baby were to be abused. You would never known that, correct?
I never would have known, and I don't think that I would have known the full extent of this case had the baby was flagged as soon as he got to England, because England saw that it was a form of human trafficking, and that's why they took the incentive and placed him in foster care.
Ms. Law, is there any, and it's illegal, we need attorneys, but God, I can't believe I just said we need an attorney. Man, we have reached a new low today. Here's the question.
Cringe for you on that one.
Is there, and I know it goes to the individual right, but is there anything in anybody's world that you've seen that, I know that foreign countries are just straight out prohibiting it, in the 50 states that we serve in this country, are there any on the books prohibitions for birthright citizenship, tourism, those kind of things that?
Absolutely not. I mean, I've been fought, it's a state-by-state battle here in the United States, because there isn't any overlay from the federal government on how any of this is managed or mismanaged. And so far, the tide has been against us. Every single state that's changed or added books on the book, Washington State, New York State, Michigan. Michigan was the last state that fell. Michigan didn't recognize any of these contracts as legitimate contracts, so they were non-enforceable. And they have now legalized commercial surrogacy, I believe, last year. So it's only because I think the public awareness, whether they be outraged by seeing, two men holding their cute little beautiful baby, or the whole awareness now of this tourism problem, has it even raised to a level of conscious raising. I mean, this is a breath of fresh air, honestly, to be here today, where serious questions are being asked.
Well, the bottom line is it's about the kids' benefit and welfare. And so I don't know how you could argue that it's good for a kid be part of a transaction that is associated with a sale subsequent to that or through foster care. This IP parent's got to have a biological connection, preferably 50% of the couple has to have some. If they don't, and they truly don't, and they're searching, we can point them to a foster care system. But these agencies, they're probably not housed in Texas. They're probably incorporated out of Delaware or wherever. But point being is, I hate coming in with regulatory, but at the end of the day, we need some work on the backside of this in Texas and clean this up and get some specificity to it, that where these gestational agreements are not hit and miss when a hospital gets them. When do you get that gestational? Is it the day of the birth normally?
Oftentimes it is, yes.
Wow.
Sometimes there's some, some sort of planning ahead, but very often it is when the mother comes to the hospital to deliver the baby.
Wow. Yeah, it needs some cleanup.
Big. I have to tell you all this, and I'm very serious about this. I'm so grateful to the Lieutenant Governor Patrick for this charge. I submitted it. We'd been following it for a while. There's been some things. I quoted the Chinese billionaire and what had happened in California, and this is. When I say this is heavy 2 days, yesterday we talked about a lot of different things in this issue. While Florida had a bill, we really are, one of the first states to really look at this. And this has nothing to do with the SCOTUS ruling. I mean, we got these charges, back in late February. This was really about just trying to figure out surrogacy tourism in many ways and the ethics of this. Senator Blanco, and I have a couple of follow-ups to the questions asked by the members.
Thank you, Madam Chair. Dr. Doss, I've got a couple of questions, data questions for you. Of the couples that seek out a surrogate, do we know what percent of them are pursuing surrogacy as their last chance to grow their family? Do we track that?
I don't have that data, no.
Okay. Do we track how frequently those use IVF?
So in one of the items that I had mentioned that's collected as like public health data, risk factors in this pregnancy, that includes some options for IVF, but that's up to the person reporting that that this pregnancy resulted from infertility treatment, and then they can check off IVF. Yes.
Okay. Can you provide that data to the committee?
Yes,
That'd be helpful. Thank you.
I have that.
And Senator Blanco,
And
follow
not
up to
now.
that.
That could be later on. Yeah.
No, Dr. Doss, also that worksheet that Senator Hughes and you said,
Yes.
would you provide that to
Yes.
the committee? We'll disseminate it to y'all. Thank you.
Thank you.
I will, Senator.
You noted the increase in surrogacy over the past 10 years in Texas. Do we have any data behind that growth that might explain why more families are turning to this option?
I don't believe that I had said that it had increased, but I also don't have insight into the reasons for trends in the type of record being reported as part of birth registration.
Okay. I mean,
But you're
it
right.
shows- yeah.
There is a if you're looking at the chart it's
Right.
showing an increase in the totals, but I don't have insight as to why.
you all don't track it.
Correct.
Got it. Okay. Thank you. I guess for the panel, regarding the court's criteria for approving gestational agreements, do you find that criteria sufficient to ensure transparent contracts for surrogate mothers?
I think that's outside my
Yeah.
scope.
Yeah,
Yes.
I figured that, but for the panel?
Yeah. If anyone else-
You do have to have specific findings, Senator Blanco. You may be looking at this section 160.756. There are some specific findings that the court has to make, including, maybe to an earlier point, that the medical evidence shows that the intended mother is unable to carry a pregnancy to term and give birth to a child, or is unable to carry the pregnancy to term and give birth to the child without unreasonable risk to her physical or mental health or to the health of the unborn child. Those are criteria I think, perhaps the legislature should look at, but there's specific findings that a court has to make, and that's where you would find that in the statute.
Okay. And earlier we heard some statistics, I think 3 cases from DFPS. But do any surrogates ever report it to the state as being exploitative? Do we have any of that data?
I'm not aware of that, Senator. Certainly, as I think was alluded to earlier, hospitals, medical professionals have a duty to report if they have reasonable cause to believe that abuse or neglect has occurred or may occur. And certainly we, take that obligation seriously. I am sort of blanking on whether there's a corresponding reporting obligation for exploitation of a surrogate mother or trafficking. Perhaps other witnesses know that.
Commissioner, you know of anything in those?
Yeah, I would say, I mean, all people in the state of Texas are mandatory reporters for abuse, neglect, and exploitation, including human trafficking. So for a child, those would always be required to be reported to DFPS. Exploitation of the, as it's called in Texas, Family Code, gestational mother, I'm not sure if there is a reporting requirement for that.
Okay.
I'm not aware that there is a reporting requirement for that.
Excellent question.
Thank you. Ms. Lal, the data that we heard today, depending on how you look at the data, from my perspective, paints a positive picture of surrogacy in Texas, showing it to be overall safe and secure in our state. Are you concerned that any of your recommendations would restrict surrogacy options for couples who need it as their last opportunity to grow their family?
I don't think anybody can risk a woman's life because of something they need or want. I guess I would say we don't need children. We want children, and that's a good thing. That's a normal, natural desire. But I'm before the Health and Human Services Committee. Surrogacy is risky to women's health. So I'm not comfortable saying because this couple's nice and they pass the background checks and they're financially stable and they're not breaking any laws, can then therefore risk another woman's life.
Mm-hmm.
That makes me very uncomfortable as a nurse and as a bioethicist.
Yeah.
So I
Sorry,
think.
did you say we don't need children? We want them? Is that what you said?
I said we don't need children, we want them. I mean, if I don't have a child, even if I'm a cancer patient, I need chemotherapy.
Mm-hmm.
You know, if I'm homeless, I need shelter. You know, I think, you know, nobody has a right to a child is what we say often. You know, we want children, but we don't have a right to them. We don't have a right to risk another woman's health because we desperately want. Maybe you think you need a child, so I'll concede your language. Just because you need something.
I'm sorry, that was your language. No.
I thought you said that. What about?
I was clarifying that that's what
Okay,
you're saying.
sorry.
But you
I'm
did
not
say
trying
that.
to be disrespectful.
No,
Anyway, that's the problem for me. I mean, this Christian took medication she had no medical need to take. There was no reason for her to take these drugs. She underwent medical procedures. She had no medical need to undergo medical procedures. She had an emergency C-section. Was it emergency? She had preeclampsia. Preeclampsia carries lifelong high-risk complications to your heart health. Women who've had preeclampsia during pregnancy have much higher risks of heart attack and heart disease as they age because it does such significant damage to the cardiovascular system. So why would we take healthy young women and, oh, by the way, offer them money that they maybe need? You know, Christian needed the money, and risk their health? You know, we tell people don't smoke, when in fact most smokers don't ever get lung cancer. We say don't take the risk. So why are we risking young women's health who are young mothers themselves? You know, the surrogate mother in Idaho, Brooke Brown, she was carrying twins for a couple of Spain. She died, and the twin she carried died because she had placental abruption, which is massive hemorrhage. She had massive hemorrhage. Anyway, it's hard for me to,
As a bioethic.
yeah, as a
Ethic,
nurse,
as
as
a-
a bioethicist, to concede that we have the right to risk a woman's health and have her do things to her body that are not medically indicated.
Last question. So my district shares a border with Mexico, and many families that I represent come from both sides. They've got citizenship in the United States and Mexican citizenship. So they've got mixed nationalities or mixed immigration status. And some of those families might need to utilize surrogacy if they want to grow their families. A ban on allowing international surrogacy would directly harm them. Do you all consider those kinds of families making your, based on your recommendations, do you all consider those types of families that are mixed status? I guess that's for Ms. Law.
You know, I always say I don't care if you're gay or straight or single or mixed or whatever. My point is, you don't risk another woman's health because you want to grow your family. Is that that clear?
Thank you. Mr. Wallab, earlier was reference of these billboards in other countries that are saying have advertising hospitals and things like that. What have you all seen through the association? And what is the association doing about that, or how do they address it?
This most specific instance that's been reported, I need to preface my remarks by saying the only thing I really know about that is what I read in Governor Abbott's statement and what the chair mentioned earlier, and then I think a little bit of news coverage that I was able to look at. So I don't know anything about that specific situation. I guess what I would say generally is, we've made great strides in this state in maternal care. It wouldn't surprise me. It shouldn't surprise anybody that a border hospital might advertise for its services in Mexico. And so, so I don't know about the specific situation. That may be really all I can say. We don't have a position on it at the association. What Governor Abbott described in his statement is alarming, and we don't have a policy statement, but I can't imagine we would support something like that if that's kind of what the facts bore out. But I'm not sure I can say much more about it than that.
Is that something y'all are going to start tracking?
Well, I think we're going to try to understand what's happening, what has happened in this sort of most recent example, and what Governor Abbott is talking about, and then we'll go from there.
Okay, thank you.
Thank you. Senator Cook.
Thank you, Madam Chair. I just really, really appreciate all of y'all and all your testimony today. These conversations get into like beneficence versus paternalism, and there's just a lot to go there. So just thank y'all so much. I do want to just say I am seeing some very distinct issues come up. And for me as a nurse, a lot of nurses, it's health. It's health. And that to me, you can get into a very just anti-immigration space with some of this conversation. And I'm just so thankful that we're here in the Health and Human Services Committee to talk about health. I think that's so important. And it's simultaneously new technology and also age-old questions. And Ms. Ross, I especially just want to say thank you to you. It takes a lot and a lot of generosity from you to come and share your story with us. And I think we can all agree that shouldn't happen to you. And so I just really appreciate you.
Thank you.
Dr. Doss, just curious, how long has there been surrogacy options in these records?
We've been collecting that data in our electronic reporting system. 2015 was the first year that I saw the record types of the surrogacy 1-parent and 2-parent, but it was a partial year in 2015, and then 2016 being the first full year.
Interesting. Okay. And how long have gestational agreements, kind of this category of contract, existed?
It looks to me like the statute was passed in 2003. I don't know if there was a previous version of this, but I would guess 23 years.
Okay. So prior to 2015, was it paper records or electronic?
It was still electronic, but I was not here, and I don't have access to any of the background as to what happened in those years to, if anything, for reporting these births, and then why it started in 2015.
We can follow up. Thank you. Thank you, Madam Chair.
Senator Cook, I have some stuff here, and I, as I always tell y'all, I have so many pieces of paper. Thank you, great staff. But there were some laws on this starting in 2003, one of which was never funded or, hold on a second, if I can get to this. I'll kind of, the 78th session in 2003, that would be my second year in this building. House Bill 729 by Representative Goodman and Dutton and Senator Shapiro updated this section of code to require reporting and data tracking for IVF clinics and surrogacy. And then this was never implemented and likely due to lack of direction and funding. So, it kind of goes back to 2003. I think 2015 we have some incomplete records, and then 2016 is what y'all have kind of guided us as we begin to look at that. So a little bit of a deep dive. I think that was a great question that you had there, Senator Cook, and I'm happy to share that with you because I was like, why do we have some? It happens. Why we have something on the books and then it's never implemented. I'm going to jump into a couple more questions, follow-ups from our senators' questions. Ms. Ross, you said something, and I don't think I thought about it this way. You kind of talked about human trafficking, and I kind of started thinking about what the questions were from the members, and then I kind of wrote down the word baby trafficking. Kind of stunning.
Yeah.
When I think through that, Commissioner O'Neill, your answer to Senator Blanco about the surrogates and not really following up. So I'm going to ask this question. Is HHSC present? I'm going to ask a Medicaid question. Medicaid question. Who wants to do it? Boy, y'all are just jumping up wanting to do that, aren't y'all? I'll take anyone. I'll state the question. Y'all can bring someone forward. So I'm going to go to Mrs. Ross. Ms. Ross, your when I'm looking at this advertising, and I will tell you that there is a billboard. You know my rules about billboards, and I'm going to read y'all this billboard. It's on I-35 right here in Texas. Become a surrogate. Earn $74,000 plus. Women-owned business, 20 years in business. And I was sitting here with the statement that Ms. Ross said. I think it was Ms. Ross, maybe it was you, Ms. Law, that said that many times it is women of, I'm going to put it like this, lesser means. I don't ever think there's poor women. I think we're blessed. But women of lesser economic means that are many times targeted. If I'm driving down the road and I see $74,000 and I really need some money, I would, as a young woman, maybe consider that. So here's my question. Ms. Ross said that she had to use some of her insurance. Am I correct on that?
My what?
Do your medical insurance?
Yes.
So in Texas, we cover women of 185% of poverty level or less in Medicaid. I believe I'm right on that percentage. So if I am a woman that qualifies for Medicaid, are the Texas taxpayers paying for these surrogate mothers to give birth?
I'm not sure about here in Texas, but I know that the
Ms. Ross, you don't have to answer that.
Okay.
I'm
I
not.
know you're like, why am I here from Pennsylvania?
No.
Texas Medicaid.
I don't believe we do. I would need to verify that, and we can follow up with that.
So if a woman, and it's just a curiosity, I'm not being accusatory. I just need to try to, again, I'm wrapping my minds around. I started with a beautiful morning, and we've gone down some alleys here that I think are bioethics questions that we've never quite asked in this chamber. So would you find out for me?
We will find out.
Because if a woman qualifies for Medicaid, it's mandatory. I mean, they qualify. The hospital's going to qualify her.
The only thing I would add to that, Senator, and I am not a Medicaid expert, is that Medicaid is the payer of last resort. So if there's some other agreement where someone else is responsible for paying for the medical expenses, I think that could impact whether Medicaid would pay for those services.
Ms. Law, you wanted to add to that?
Well, I just wanted to add that chances are pretty high that that is how the pregnancy is covered, is through taxpayer funding. If it's a situation where the gestational surrogate doesn't qualify for state funding, but doesn't have insurance, the intended parents typically have to purchase health care insurance for her for the duration of the pregnancy. But it's a big money saver if the intended parents don't have to bear the burden of carrying an insurance policy. So they're happy to have the taxpayers.
Thinking the
cover that.
surrogacy agency,
Yeah.
this is a business model, right? We would all agree. So they're getting paid up to $500,000. If they don't have, I mean, this is no different than any business, I think. So we're going to stay there with the billboard issue, okay? So this particular billboard in Texas, it says earn up to $74,000 plus. We're looking them up, and any member that wants to know the name of them. This agency says is the oldest and largest full-service surrogacy agency based in Texas. We were founded in 2002 to assist couples and individuals with the desire to achieve a family through third-party assisted reproduction. We were founded on one simple principle: to provide our clients with the highest standards of care in the surrogacy industry at an affordable price. Remember, baby industry, price. So let's go down, and it lists the surrogacy team. We have the co-owners. We have the senior surrogate coordinator. We have the executive intended parent coordinator. We go on down. We have a midwife and a registered nurse. We have the director of surrogacy screening. We have the executive egg donor and intended parent coordinator. We have the West. This is where it gets interesting to me. The West Coast surrogate coordinator and social worker for a Texas business. Then we have one of my favorites, the UK coordinators. I would think that stands for United Kingdom coordinators. And then we have the foreign relations liaison for this Texas company, who is certified in Chinese translation and Texas court licensed Mandarin interpreter. What are we doing here?
Make it make sense. That's what I keep saying.
I really think that, Senator Blanco, your questions about parents that are seeking, your original intention in getting into this, Ms. Ross, because you had friends who could not conceive.
Yeah.
I don't think that we need a Mandarin interpreter in a Texas company.
I think that just goes to show you how loose it is. Right there, you're
Or
reading
the
it on
UK
your own.
coordinators. So I'm going to ask a couple of follow-ups to that. Is there anything in federal or state laws that prevent the IPs from putting a child up for adoption?
No.
No.
Can you lean forward?
Nothing that I'm aware of, Senator.
No. In fact, that's one angle that causes the higher rates of postpartum depression in surrogates, when they know things have gone south and not knowing what has become of the children, knowing that the intended parents changed their mind and didn't want them. One California surrogate was pregnant for a couple in China who ended up getting divorced during her pregnancy, and so they asked her to terminate the pregnancy, and she wouldn't. And so she was told that once she gave birth, those children would just be immediately given up for adoption.
Yours was put up for adoption, right, Ms. Ross?
He was, but it was in the original plan all along. Once I went and got embroiled into this custody battle in England, I had learned that there was another contract in place between the intended dad and the sperm donor that I wasn't aware of.
Mr. Wolof, is there anything that prohibits the intended parents after they have, other than the penal code of you can't sell a child, but you can put that child up for adoption? correct? After the surrogate.
Correct. Nothing that I can see in the statute.
And Ms. Ross, one more question. If you had had a miscarriage, would you have been paid your full amount of money?
No.
Explain that to me.
So if I had a miscarriage, like I said, they had broken it down into monthly payments, and whatever my last monthly payment would have been at whatever point that I had miscarried. And I believe whenever I thought I was miscarrying, I was only a few weeks pregnant, and so I wouldn't have gotten anything other than long-term repercussions.
Do you get a signing bonus?
No, you get bonuses if you refer people though.
What?
Yes, if you refer a friend to the surrogacy agency, and that friend goes through, you do get incentive that way. So it's like refer a friend program.
And to follow up with Senator Blanco's question about the well-being of the surrogate mother, so up front you get nothing. You only in your contract. I don't.
Correct.
Every contract can be different. Am I correct on that?
You are correct.
So you got nothing to say, I'm going to be a surrogate and I'm going to try this. It would only be if the pregnancy, if you became impregnated and began to carry the child.
Correct. Now they did pay for travel expenses to get me to and from the West Coast to the East, or the East Coast to the West Coast for the procedures. However, that was about it.
Ms. Law, do you know anything on your studies of this, about that? Women are only paid monthly, usually in these contracts.
Yeah, it's usually a stipend that's given monthly. They don't get a lump sum at the beginning of the pregnancy. And there's oftentimes, like, she was given an extra bonus for a C-section, which is a lot of times in the contract. It's also in the contract if you happen to have a hysterectomy because you hemorrhaged, you're paid a lump sum extra for losing your ability to have babies if you lose a fallopian tube or an ovary. So everything's kind of line item, like the value of these things if you're harmed and they have complications.
You stated to Senator Blanco that you're not a fan of this and that you have the Center for Bioethics and Culture Network. But there could be situations where someone, a family member, a friend, could help another friend. It is risky, correct?
Yeah, it's absolutely risky to the point of being life-threatening possibly. Yeah. I mean, I know several situations where a sister helped a family member and I actually have a book. It's called Broken Bonds, Surrogate Mothers Speak Out. And several of the stories in that are women who did it for free to help a family member or a friend. And things went terribly south.
But there are situations when we've concentrated on the business today, the billboards, the money, the monetary payments, but
And it makes no difference to the baby who's separated from that, birth mother and all the magical, wonderful, good things that happen mysteriously in the womb and the child bond connection. The baby doesn't care if there was a financial transaction. The baby doesn't care if, the baby doesn't know. The baby's only aware of that woman that gave birth to them.
Senator Blanco.
Thank you, Madam Chair. I want to go back to the Medicaid coverage. And Steve, you had said that Medicaid is the last resort. In many of these cases, these are financial transactions, so the surrogate is typically covered financially for most of it. I want Ms. Law, just to clarify your statement. You had suggested that. Or I guess, let me ask you to clarify your statement. What was your statement regarding taxpayer funds for surrogates?
Well, there are cases where a woman is on, state assistance for her health care, and if she happens to enter into a gestational agreement during that period of time, then that state-funded assistance would cover the pregnancy. Because it's not, we only cover pregnancies if you're keeping the child versus it's a surrogate pregnancy. And when in fact, that is awfully attractive to the agencies and the intended parents because it's one less thing that they have to cover, because most of the time, any agency worth their salt, and most of them, sorry, they're not worth their salt in my book, won't enter into a pregnancy without having medical insurance to cover the pregnancy. So that's one less cost, because typically that cost is punted to the intended parent. So they would have to purchase medical insurance for usually it's 9 months plus a postpartum period to manage the care of the surrogate.
And your data source
My data source for,
for these situations?
well, it's just, I'm sorry, it's just my experience. I mean, I just know that, in fact, most doctors aren't going to get a woman pregnant in a surrogate arrangement. I don't have any data source, I'm sorry. It's my
Nope.
experience.
Have you read those contracts, or you?
I have, yeah. First thing I do when a surrogate contacts me is say, let me read your contract so I know what she can and can't say before she gets herself into trouble.
But you don't have any data that suggests Medicaid's covering the tab for surrogates.
I do not.
Okay,
I'm not sure if it exists. I don't have it.
thank you.
And to follow up with that is, I think the answer was, we don't have any data.
I'm not aware of any data. One thing that I did learn is that potentially if there's a transaction involved, that income would be considered as part of their eligibility and may affect it. Yes.
So if they're paid 74,000 plus, of course we have, we're dealing with this right now. We have a lot of lagging data. Commissioner Muth and I have had conversations about that. So let's follow up on that. And it was just a question that came to me as I was I'm doing some mind mapping over here, and I was reading, and I was like, well, who pays for the birth of the baby? And I think that's a very important question.
Yes, we certainly will.
Because if the Texas billboard says 74,000 plus, the woman could be losing money at the end of this if she has to take on all those costs. So somebody's paying for this. And I would say, Ms. Law, and you can follow up if you have contracts that could allow us to see about that. Members, are there any other questions for this panel? We have a lot of work to do here in this space, and I appreciate Ms. Ross, again, your journey. I know there are other women like you. There could be surrogates that would testify today that say it was a wonderful experience. God bless you all. Thank you.
Thank you.
Thank you.
Members, we'll now move into the monitoring portion of this. The Lieutenant Governor gives us charges and asks us specifically to monitor certain things, and then, of course, a charge that while this could potentially be our last hearing of Health and Human Services before during this interim, not necessarily if something comes up in the need to monitor. But today we will monitor the Department of Family and Protective Services Abuse and Neglect Central Registry, which is Senate Bill 1 of the 89th session and House Bill 3595. We'll call up a panel of witnesses to testify on these bills and programs. We will, by each item, I will call your name as you come forward. Commissioner Audrey O'Neill, Dr. Timothy Stevenson, David Costron, and Michelle Dion, and I always butcher your last name. Vahalik. I should do better with that. Commissioner O'Neill, is this your first time to testify as the commissioner, or did we have you already?
This is my first time in front of this committee, I think.
Well, congratulations.
Thank you.
We're so pleased that Governor Abbott would appoint you to this position, and we look forward to working with you on these issues. So we'll, do you want to start with the DFPS abuse and neglect?
Sure, yes.
Start there.
Audrey O'Neill, Commissioner. I have the great privilege of serving as the Commissioner of the Department of Family and Protective Services. You should have a presentation. I am not sure if this is the one you're getting right now, but that looks like the one that's up on the screen. What I want to talk with you about today is work that DFPS has undertaken for the last year around the Abuse and Neglect Registry, referred to in Texas as the Central Registry. Just as a bit of background, last session, which was my first session employed at DFPS. I was serving as the deputy commissioner. There were a number of bills that were filed highlighting interest and concern in the central registry and in expanding due process. Over the interim, we have taken that as an opportunity to go back and review due process with the intent of really coming up with ideas to strengthen due process for consideration by the legislature, and so that we can implement internal improvements where possible. We started by highlighting this as a major issue in our sunset self-evaluation. As you all are very well aware, DFPS is currently undergoing sunset review as we kick off that process by a very thorough self-evaluation, and this was highlighted as our first issue in our major issues section of our sunset self-evaluation. So I'm going to skip the next several slides, which really highlight our vision, mission, and values, which this committee is very familiar with. But I will just say very briefly, we are very, very focused at DFPS on collaborating with families and communities to capitalize on the strengths of local families and their community support systems to keep children and adults safe so they thrive. So I'm going to jump all the way to slide 7. And I want to just start by, I want to tell you sort of what I want to cover today. First, I'm going to share some background on the Central Registry. I do think there are sometimes conflicting impressions of what the Central Registry really is and is not. So I want to start by clarifying what is the Central Registry and what is not on the Central Registry. Then talk some about our current records retention process and the Central Registry. And then I'm going to share some data on investigation outcomes and who is included on the Central Registry. And then finally give you an overview of some current actions that we have ongoing at DFPS right now, as well as ideas that we have to strengthen the Central Registry that we anticipate sharing for the legislature's consideration next legislative session. I do want to clarify that DFPS has two very different investigative functions. One is family investigations, and that makes up the vast majority of investigations that DFPS conducts. But the other is licensed investigation. So that's going to include any kind of investigation in a daycare, in a foster home, in a residential treatment center, for example. That second group, they have already different access to due process, which I'm happy to answer any questions about. But this presentation really focuses on due process for those in a family investigation and how we might be able to strengthen their opportunities for due process. So continuing on slide 9, just starting off, the Central Registry is composed of exactly two things. If you have a reason to believe finding, which reason to believe finding and under Texas statute requires a preponderance of evidence. So if you have a finding of reason to believe, or you currently have an open investigation. Those are the only two things that make a person be on the Central Registry. It's very important to understand that individuals with a finding disposition of unable to determine, which represents a relatively small percentage of our investigation results, and of course individuals with a ruled out, which is a majority of our investigation results finding, those individuals are not included on today's version of the Central Registry or any planned version of the Central Registry. The next slide shows who can access the Central Registry. Central Registry access currently is limited very narrowly to DFPS and HHSC. No, DFPS does conduct some central registry checks on behalf of other organizations. For example, we conduct central registry checks for CASA organizations, but the only entities with access to family investigation central registry records are DFPS for certain kinds of employment checks, volunteer checks, et cetera, and HHSC, who is conducting background checks for individuals applying to work in a daycare center, applying to be foster parents, applying to work in a general residential operation or something to that extent. Slide 11 shows the kinds of entities that do not directly access the central registry, but for whom DFPS does conduct central registry checks. So if you are going to be an employee of a community-based care organization, DFPS conducts the central registry check for that. If you're going to work in a TJJD facility, if you're going to work with Superior Health, we conduct those checks and provide match information where match information exists to that entity. Slide 12 is really designed to address the common misconception that these other entities access central registry information. The entities that you see listed here, including TEAs, school districts, churches, local elementary schools, private schools, those entities do not have any access to the central registry. The only way that entities like this can access the central registry is if they request that an individual request their own central registry record. So for example, if I wanted to go and volunteer as a youth group leader at my church could say, you must go to DFPS and get your central registry record, and we would provide that record to that individual, but we will not directly provide that record to the local church that the individual is working to, wants to volunteer with, for example. Slide 13 talks some about what the results are of a central registry check. So, and I will say here, we are very cognizant that that an individual's presence on the central registry can have significant consequences for that individual. It can prevent an individual from being able to gain employment, for example, in a daycare center. It can prevent an individual from being able to volunteer as a CASA worker or work as an intern. So we are very cognizant that there are real employment and volunteer life risks to individuals who are listed on the central registry. So the next slide, slide 14, really though I think provides important context for that. You'll see in some data here in a little bit that the vast majority of central registry checks are conducted by child care regulatory as they are for individuals attempting to work in a daycare center and some sort of other licensed operation. Both DFPS and HHSC do not just effectively ban people from employment based on a central registry match. Almost the vast majority of individuals who have a central registry match go through a risk assessment process if they hit a match to determine whether there is a risk to them working in an operation with children, for example, in a daycare center. This process is completely separate from the opportunities to seek due process. It has nothing to do with an individual's due process. Rather, it is really a look at, based on the RTB that an individual had, do we believe that individual presents a risk potentially to children? And CCR and DFPS consider a variety of things in making that determination: the type of finding that it was, the length of time that has passed since the time the finding, what the role is that you're going to have in the organization. So there are a lot of elements that go into making that decision, and we'll show you later in the presentation data on what the outcomes of those risk assessments typically are. Just very briefly, I do want to mention CMARC, since obviously CMARC is very, very front of mind for us, particularly at DFPS right now, and I know many of you. CMARC, I want to be very clear that CMARC is really not impacted by the presentation that I'm making right now, and that is because CMARC, as it is currently constructed, does not include the results of family investigations. And I think part of the reason for that was some concern around due process. So right now, CMARC will include individuals with RTB findings in child care investigations, in schools, daycares, for example, when there is a sustained finding, which means that individual has to have exhausted due process. So for that reason, it will not include family investigations. So continuing on slide 17, currently the central registry is tied directly to the retention of records by DFPS. Retention periods vary based on the allegation, which I think is sort of as we would expect, but a neglectful supervision finding that maybe is addressed through family-based safety services or something to that effect, that is maintained for a much shorter period of time than would be a sexual abuse finding or a physical abuse finding that resulted in a fatality, for example. So the period right now in the records retention schedule varies from 5 years to 99 years. There's a link there for you to look at that retention schedule if you'd like to. But the important distinction that I want to make here is that DFPS is very grateful for funding of our new case management system, or the first part of funding for our new case management system. But our intent will be, when we build that new case management system, to build a separate module that separates out the central registry from the rest of the records that we need to maintain.
So I'm going to interrupt, break my own rules here. The problem has always been that, or what we've run into and we've seen legislation, and just for the audience, Senator Birdwell is about to be sworn in as the Assistant Secretary, I think, of the United States Army. And so some of the members are flying to D.C. today for that ceremony. But he had a bill and others. When you say it's a separate module, what we had found was any RTB, no adjudication, you're on some registry list, potentially, as you said, up to 99 years. There was no way to really purge those records in a way. Is that what our goal is with that separate module?
Yeah, our goal would be there are valid reasons that we need to maintain records. For example, if you are a child in foster care, you are entitled to your records when you are an adult. So we don't want to purge those records. But you're exactly right that until now, we are essentially manually parsing them out, and the new case management system will have a separate module. It will still be in the case management system, but it will be a completely segregated module that will just be effectively the listing of names on the registry. And up to this point, that is not something that Impact is capable of doing.
And didn't you give us a fiscal note of, I mean, it might not have been you, but someone in the agency gave us like $493 million to create. I mean, like, it was like that kind of number, Senator Blanco. It was like, you got my attention, $500 million to fix this.
I don't recall but it was a much larger number than what we anticipate this will cost, because we're able to do it as part of building the new case management system. Sure. So continuing on the next slide, this shows our current due process that is afforded to individuals with a reason to believe finding in a family investigation. So first, of course, an investigation is concluded, and that individual is notified of the results of that investigation, and they are notified of their right to file an appeal. If they elect to file an appeal, that is going through DFPS's existing administrative review process. You might hear this referred to as an ARIF, of Administrative Review of Investigation Findings. The first thing that happens is they have the option to request their records. We actually have changed this process in the last couple of years so that we can process that records request a little bit more quickly and without putting the burden on the individual requesting their ARIF. And then once the records are received, if the individual would like their records, not all people pursue them, but most do, then DFPS staff who are separated organizationally, they are not part of our investigations function. They report completely separately through our director, our deputy commissioner for operations. That team conducts an independent review called the ARIF. They notify the individual of the findings. If they make a decision to overturn the finding, then that finding is actually changed in impact. So it will actually be changed, for example, from a reason to believe to a rolled out with a note that it was changed through the ARIF process. If they do not overturn the finding, if they uphold that finding, then there is an opportunity right now in our current process for a second level of review conducted by another team outside. That is actually something that as we move forward, we don't really think it makes sense to have this 2 levels of review internally. So you'll see when we share our proposal, an external review, and then we would propose eliminating that second level ARIF at that point. You see some timelines on the bottom here. What I'll just highlight is that on average, an ARIF takes about 62 days to complete, minus the time that it takes us to process that records retention crest. As you all, I think, are very well aware, we receive a lot of requests for records. This is prioritized as a type of request. Most of those records take approximately 45 days to gather. So when you add all that together, you're looking at, a period of 90 to 120 days, typically from the time a person gets their finding and requests an ARIF to the time that ARIF would be completed. Not shown on here, but I do just want to share, if the finding is upheld or the individual does not pursue their option for an ARIF, and subsequently there is a hit by CCR that actually bans them for employment, or by DFPS, at that time that individual is provided the option to go to SOA currently. There's a very narrow population of individuals that are going to meet that criteria. So most individuals in family investigations currently are not afforded the opportunity to go to SOA. Okay, so next I want to just share some data so you can sort of understand what it really looks like. On slide 20, this shows the types of central registry checks and the numbers for most of those kinds of checks. But what you'll see here is that most central registry checks are performed by HHSC, Child Care Regulatory, for individuals seeking employment in a daycare or in some sort of other licensed child care operation. DFPS does perform checks for potential DFPS employees, juvenile justice employees, kinship placements, a few others there, such as CASA. And then if you see that bottom left-hand box, that is those self-inquiries that I was referencing, so that it's if I request my own central registry records. I should also note that we are actually required by federal law to run those checks for other states. So if, for example, a foster parent that lived recently in Texas wants to be a foster parent in Oklahoma, Oklahoma may request that we run that central registry check. We're required by law to do that, and of course we do so. Slide 21 shows that the vast majority of individuals listed on the central registry are on the central registry because of the results of a family investigation and not the results of a licensed child care investigation. I will say this should not feel surprising to us because the vast majority of our investigations are in family settings and not in licensed care settings. Slide 22 shows the individuals that are listed on the central registry based on the type of RTB they received. So as you can see, there's about 795,000 individuals that are currently listed on this central registry. The gray and the orange there is really to make the point that most people on the central registry have been on the central registry for more than 2 years. So the gray is individuals who were added to the central registry more than 2 years ago, and the orange is individuals who were added to the central registry within the last 2 years. As you can see, about 7,000 individuals are on the central registry because they had a reason to believe finding for a fatal or near fatal abuse and neglect. About 158,000 are on the central registry as a result of physical abuse findings. Another 361,000 for other types. That would include things like sexual abuse, trafficking, could include physical neglect. But the remaining 412 are on the central registry because of a finding of neglectful supervision. And if you flip to the next slide, you'll see that about 53% of individuals who are listed on the central registry only have a finding for neglectful supervision. So that is really that we wanted to look at this data this way to really guide where we wanted to focus our first efforts. And this is the area that we see the opportunity to really focus on those first efforts. I do want to be very clear. There are individuals with neglectful supervision findings on the central registry that are extremely serious, and there is probably a good reason for some of those individuals to stay on the central registry. But the reality also is that the statutory definition for neglectful supervision has changed a lot in the last 6 years. And since a lot of those individuals had findings that predated that, it really makes sense to ask ourselves, should those individuals still be listed on the central registry or not? So continuing on slide 24, as we discussed, there is a risk assessment process that is used in the vast majority of cases. There are some cases that both HHSC and DFPS conduct background checks for that do not qualify for a risk assessment. So for example, if you have a finding of sexual abuse, you are not eligible for a risk assessment. That is an automatic bar to employment with children. If you have a serious physical abuse RTB, that is also, you're not going to have the opportunity to have a risk assessment process. But most of our RTBs are for neglectful supervision, and all of those individuals have an opportunity, and it's just automatic. They don't have to request the opportunity. If there is a match, they go through that risk assessment process that I described earlier. And what you can see here is that of the matches, so HHSC ran more than 2.4 million background checks between fiscal years 2020 and 2025. Only 30,595 of those checks resulted in a match for the individual. Of those 30,600, only 4,716 ultimately resulted in a bar to employment. What that tells us is that the risk assessment process is actually identifying many individuals with RTB findings whom HHSC staff determined do not present a risk, and those individuals are allowed to go and work, for example, in that daycare setting. And I do think that is our intent. Again, we know that those individuals, that mom could have had a neglectful supervision finding from when she's 20 and now she's 31, right? And she could have demonstrated a lot of changes in that period of time. And frankly, it might not even meet today's statutory definition of neglectful supervision. So I think that I believe that that is evidence that that risk assessment process is working as it was designed to work, because we are making a distinction between individuals who present such a risk that they should not be working in that kind of operation, for example, daycare center, versus individuals who made a mistake, but we can feel confident that they no longer present that kind of risk. You can see the slide, it's the same data a little bit differently, but as you can see for each of the last 5 years, less than 0.25% of individuals for whom HHSC runs a central registry background check are ultimately barred from employment based on that central registry check. So I next want to move it. There's a bunch of other data I'll just tell you briefly at the end that I'm not going to go through, although I'm happy to answer questions on. What I want to conclude with is talking about what actions DFPS is working through right now and actions that we are developing for consideration by the legislature next session. So this first slide here, slide 27, focuses on our current efforts. In 2024, we implemented a new quality assurance process around child protective investigations. And thanks to funding that we received from the legislature last session, the 89th session, in December 2025, we implemented a team of reason to believe readers. And that team, those team members have to they're statewide team housed out of state office, and they have to read an investigation that is going to have a reason to believe disposition before we close that investigation. And that was designed to really improve our consistency across the state. And it's very early, but we're very excited at the results that we're seeing with that team in place. We're also, we are in the middle of efforts to improve our ARIF administrative review process to also improve the quality and consistency of ARIFs. We are undertaking business process redesign as we anticipate implementing our new case management system. And we also implemented a legal sufficiency review this winter. And that was really designed that before a case is going to go to SOA, we want to have our own team look at it. And this really is a cost efficiency issue that we want to do a review of the results of the investigation ourselves and make sure that we believe that we have sufficient legal evidence to meet the evidentiary burden before we carry anything forward for SOA review. And then, of course, finally, we highlighted this in our sunset evaluation. On slide 28, these are two changes that we anticipate making that do not require any sort of statutory change. We just will have to fund those, and it's not going to be $493 million, I can assure you. It won't be 1/400th of that amount, I'm pretty confident. But there's two. The first is the proposed central registry module within the new case management system. That will include the automatic removal of names when names meet their records retention period. And then, when names meet their retention period, not their records retention period. And then secondly, removing deceased individuals from the central registry. We have to have a vital records connection in order to do that, but that will not require statutory authority. This is the last set, are proposed changes that will require statutory change and also have some sort of funding element to them. So the first one there is to separate out the retention schedule from records to names. We will likely propose something around, right now we have one retention schedule that applies to everything. We'd like some statutory direction that says you have a separate retention schedule for the names on the central registry than you do the records on the central registry. And that goes hand in hand with that new case management system. That would enable us to essentially expunge names off the central registry while still keeping the underlying record that we may sometimes need to provide to the foster youth, for example, when they request their records. The second one there is to provide an option for all individuals with RTBs to access external due process through SOA after exhausting due process. This, of course, would require a statutory change. This is also something where we have seen some bills for this in the past, and those have tended to have very high fiscal notes. So we're working on presenting it in a way that will limit the fiscal impact as much as possible. For example, we will propose requiring individuals to first go through the ARIF process before they're eligible for SOA, because ARIFs are a lot less expensive than SOA. So we're going to put in some things to hopefully keep that cost as manageable as possible. And then third is two pieces. One is expanding the risk assessment process that I described to you earlier is not currently available to all for all types of background checks. So we would propose expanding that to the last few types that don't currently get that risk assessment process. And then secondly, creating an expungement panel. And again, this is something that there has been previous bills for. We are proposing a way to create this expungement panel that we hope will have a little bit lower fiscal note on it, have a lower cost. What we'll propose will include internal employees, and it will have some parameters for individuals. And it's really designed for individuals, not individuals for whom they need to access due process, but for individuals who had a valid RTB finding. They really did have a valid RTB finding, but their life is completely different now. They can demonstrate, for example, that they went to substance use treatment and they've been clean for several years. So we can remove their finding based on that demonstrated life change by them. So that concludes my prepared remarks. I'm happy to answer any questions, and also happy as you look through the additional data to answer questions separately and individually on the rest of the slides.
So a little unlike do the whole panel and then go back and ask questions, because each one of these are different presentations. I'm just going to jump in with a couple of things. So on page 12, who does not use central registry checks? So, and just for the audience, TEA, independent school districts, law enforcement and county employees, medical community, church ministries, Boy and Girl Scouts, third-party recruiting, so forth. So they don't have access to that, but they can call you and ask. Is that correct? Or
no, they cannot. They would have to have that individual request their own records. The only entities that can call or can request that we check it is the entities on the prior page, like CASA, for example,
and Superior
Big Brothers,
Health is
Big
on there
Sisters.
because they are the provider of health insurance for.
They're the Star Health provider for children in foster care.
Okay. All right, and so then skip to CMARC, which is again a build off of what we started with Senator Bencourt on he called it pass the trash or whatever. I built it out because of the issue that we saw with the trafficking issue in Bastrop with I believe a RTC there, and so I guess my question is, CMARC does not pull RTBs and other things into it.
Not as long as it's in a family investigation setting. Now, if they had an RTB, for example, if they worked at an RTC and then tried to go work for JJD, then CMARC would pick that up because the finding was in a licensed care setting.
Okay.
It just only doesn't pick it up. If that individual had an RTB as the parent, like if they were a parent in their own home, it would not pick that up in CMARC.
And in part, the RTBs again are not. They haven't gone through some formal, y'all have investigated, but you have a reason to believe, but you don't have a factual finding. So we don't want to really just be grabbing all of that up, which leads me to page, I don't know if it has a page, but your all perpetrators in central registry with RTBs for family investigations by highest RTB. 53% are on neglect, as you stated. And I want to restate, we have redefined what neglect is. So over half of the people on the RTB for family investigations are on there for neglect. So this goes to the issue, I think, that Senator Birdwell had been working on. So I skipped to page, again, I don't know, current agency actions to improve accuracy of investigations, the RTB readers. So when you look at how are you going to kind of go after those 50, not go after, how are we going to validate or make sure that we don't have people on that registry, again, as you said, that are maybe a different definition of what we 6 years ago called neglect? Does that go to the page where you say, hey, we have RTB readers and we have legal sufficiency review? Where are we on all that?
So the RTB readers are reading on a go-forward basis. So they will ensure consistency for any investigation that occurred after December 2025 going forward. We would need, as you would imagine, hundreds of them to go back and read investigations for
And I
those
see that
700 and
53%, that number is 412,000.
right. So it would take a tremendous amount of effort to go back and read those, but that's why some of this proposal, first of all, like the legal sufficiency reviews, that is something that would be going back to eliminate, to determine whether that met the preponderance of evidence standard, for example. So I will say, though, I do think that's really why the the retention period for the central registry is critical, and separating out that retention period, because that is really the thing that would allow us to address those old cases on a going forward basis, because they just wouldn't be on the central registry.
So what are you going to do about that 53%? I mean, maybe you've answered it. I just can't get there.
Well, I think part of it is that when we have the new central registry module and we have a records retention period that says, for example, and there's some details to work out here, we're only going to keep a neglectful supervision for 10 years or 5 years or 15 years, whatever that number is, they will automatically be off, and we will see that 53% reduce over time, because we'll be getting rid of all of those old investigations.
So the 33,500, that orange bar on this, is that since when?
I believe that's in the last 2 years on this. So those all meet the current standard of gross negligence. Sorry, I had to think of the word. That is that's the definitional change that happened in 2021. So now, to get a finding for neglectful supervision, a parent has to, or a caregiver has to demonstrate gross negligence in order to have a finding for NSOUP.
And so I think, Commissioner O'Neill, you said it in a way, we're going to put some time limits on it. We're going to, I guess, if someone is on this registry and makes a request, once we kind of finally have the module, there would be a way to work through it on the page that I know the RTB readers are only going forward, but there's a legal sufficiency review, so they could, which you began in February of 2026, they could avail themselves of that.
They could also avail themselves of the what I presented on that very last page, the expungement panel. That would be a way also for them to get off on a retrospective basis. So anybody would be able.
Senator Cook has a constituent, let's just say. Senator Cook, this probably was a person in your district who came to me and, anyway, came to me via Miss T. So when Miss T calls, I'm like, Miss T, this isn't my constituent. I know, but you can do this, okay? Anyway, so there's an RTB there. And let's just say that this person is like, I don't want to be on that RTB anymore. And so is that going to cost them money?
No, I don't. I mean, unless they chose to hire an attorney, for example, but I think they could go through the what we would propose as the expungement panel process. There wouldn't be a need for, it's not a legal sufficiency, so they could go through that. And if they demonstrated that they, again, maybe they had a substance use issue and they can demonstrate that that's not the case anymore, then we would remove that finding. So we'd overturn the finding and change it in the system.
Just an off-the-wall question. Substance abuse finding, is that gross neglect?
It depends on, I mean, just substance use in and of itself is not a finding at all. If you have substance use that puts your child in danger, for example, if you test positive for methamphetamines at birth and your child is born addicted to medical amphetamines, which obviously has significant health consequences for that child, that would meet that gross negligence.
Building on yesterday's hearing, so Senator Perry passed a bill that now makes, is it dishes, I think, have to report anyone that, if any baby tests positive for THC or alcohol. Would that be a gross negligence finding?
I think it would depend on the investigation, but it particularly for instance infants born addicted. Actually, in some cases, I think it's physical abuse. Yes, I'm just looking at my investigations person. That can actually be physical abuse because the baby is actually injured. But let's say mom, we have cases where mom is addicted to meth and children are wandering outside the home because mom is unable to safeguard to protect her kids. That could be neglectful supervision, because that would be gross negligence because mom wasn't keeping her kids safe, and there was a substance use problem that was preventing her from keeping her
Does
safe.
that apply to, you keep saying methamphetamines, but does that apply to alcohol, and does that apply to THC?
Yes, it can apply to all kinds of drugs depending on the level of risk that the child was at. It's really more about the risk to the child than it is the substance that the mom used.
Very interesting, just building off of yesterday and some of the testimony by the physicians and so forth. Okay, members, any other questions? Big issue will be looked at in Sunset. It's an important issue. I know these registries are important, but it's also important to protect potentially those that are innocent that find themselves on this registry, some of which I'm not sure we're even sure they knew that they were on the registry. So I'll look forward to working with you, and welcome.
Thank you.
So, Dr. Stevenson, I saw you sneak in here.
Yes, ma'am.
Where have you been?
I stepped
don't-
out just for a minute. I was here all morning.
Okay, good. I'm kidding you. I did see you. I saw that blank chair, and I was like, can somebody text him? Very serious matter, though. We appreciate your testimony yesterday.
Yes, ma'am.
And good to see you back today. Moving to the monitoring of Senate Bill 1 from the second called session of the 89th legislature. I do want to say, members, as you remember, this is the broad camp reform and licensure regulation bill. This legislation was created after the devastating events in Kirk County surrounding the areas. Just literally, this is what, July the 8th, so July the 4th, so a year and 4 days ago. We remember and pray for all the families impacted by those floods, and we hold them up in prayer and know that the 1 year anniversary was very difficult. And Senator Blanco, thank you for your service on the committee with us, by way of just saying how well the legislature works together. Senator Blanco and I and Senator Menendez, when we had the hearing in Kerrville, made the trek to and down the road to Hunt to see the devastation of that flood, see Camp Mystic, and it was, I'm not sure any of the three of us could even talk after we saw the damage that could happen. And so as a result, Senate Bill 1 was passed in the second call session, and we have since had an investigative hearing that we went through and were a part of. Senator Menendez was on that committee with me, as well as Senator Perry, Chairman Flores, our House members, a joint committee like the committee that you and I served on. And I just want to compliment the House for their partnership in these bills and how well we all work together. Senator Blanco, would you agree? Thank you. So with that, Dr. Stevenson, a review of that.
Yes, ma'am. Appreciate your attention, Madam Chair and members of the committee. Really, my focus today will be on, after the passage of Senate Bill 1 and House Bill 1, all the implementation efforts and getting into camp season. We're in the middle of, halfway through camp season for this summer. So how did we get from there to here and implementing those legislative mandates and authorities and using the resources that the legislature granted us to help protect and ensure the safety of campers? Been a long journey. We started with the passage of rules and then implementation of those, and I'll cover those a little bit by the numbers on the campers that are youth camps that have gone through the process, applied and got licenses, and are in having camps right now as we speak. And then looking forward at some follow-on actions that we're looking at to both for the legislature and for us and for camps moving forward to continue to take advice and move these things forward as best we can. Just looking at some of the numbers, we had about 375 camps in the year 2025. Those a combination of residential overnight camps and day camps. The slide says 299, but we've actually updated these numbers. 307 camps that have renewed and have licenses as of the last day or two. So we continued, we got an application actually July 1. We continue to get camps. Some of the camps have later in the summer. And so, like I say, we got one application July 1. Most of the applications came before the March 31 timeline, and we worked through those. Looking again at some questions might be what happened in the difference. Those camps that from 375 to approximately 300. There were some 107 odd camps that did not apply for a license this year. They had a license the year before. They did not apply this year. There's a follow-on slide with a little more information on some of the reasons that they may not have applied. So a fairly significant number. Some of those could have been, we know that of the camps that have actually applied, approximately 52, said they did not have end-to-end internet fiber optic connections, and that was a big issue for a lot of camps. They didn't have it and they couldn't get it, and if they could, it was really expensive, so several $100,000 even if they could get it. So that was 52, told us that when they applied. Some of these 107 that did not apply could have also fallen into that category. We don't know all the reasons why those that had a license the year before may not have applied this year. But still some 300 that do have a license this year and are operating. These are some of the big rocks, so to speak, on getting to the point where we are implementing the legislation, adopting rulemaking, expedited rulemaking process after the bill's passed in August, posting proposed rules. Those proposed rules came off comment December 19th, which means we got some of the comments December 20th, December 21. We worked through Christmas. I signed off, had a meeting Christmas Eve. A bunch of my staff working through some 807 comments on the rules. Our commissioner at the time, Dr. Shuford, signed off and approved on Christmas Day to move those on forward to HHSC to publish the rules for us and continue to work through that process. We got rules in effect February 4th, just in time for applications in the new camp season coming on. So that was the rulemaking process. A lot of engagement with stakeholders. We had hearings, multiple hearings, and opportunity for stakeholders to provide comments on the proposed rules. hiring FTEs with some expertise in emergency management, training inspectors on the new statutory requirements, emergency plans. I'll highlight one block on the slide is a contract that we put in place with National Emergency Management and Response, often known as NEMR. So we had a contract after the emergency was declared with NEMR, and they have enormous expertise in emergency protocols and procedures. We leveraged their advice that they already had in the time when we were developing and hiring those resources and developing that expertise within our department. So they were incredibly helpful. I can give some names, but they may not want their names published, but a lot of great people in NEMR that really helped us with the first reviews of the emergency plans. Every single plan that was submitted, not a single one was approved the first time. So they were all reviewed at least twice. So they submitted an application, they provided feedback to the camps on how to improve those plans, and then they came back a second time, sometimes a third, to continue to refine those plans to implement all the requirements of the statute. There were IT solutions on how to move emergency plans forward and make those available to TDM and other emergency agencies as necessary. Then of course, this year, every single camp got a pre-licensure inspection. Typically, if a camp had a license the previous year, we might not do a pre-licensure inspection if things hadn't changed very much in their operations. But we reviewed every single applicant with a pre-licensure inspection, looking at the emergency plan requirements and implementation, facilities on the campsite, and then followed on with operational inspections when camps are actually campers are there. We're in the midst of doing those now. Significant progress on those. So some successes just about the process. The application deadline of March 31 seemed to be appropriate to give us time to review the plans and camps time to respond to feedback on the emergency plans and any other issues with their application. Again, working with, incredibly grateful for National Emergency and Management and Response. NEMR was incredibly helpful with these first reviews of the emergency plans and advice on those. Stakeholder feedback, both on the rules and the hearings that we offered, were valuable. And then looking on, specifically at the emergency plans, that was, like I say, not a single plan was approved the first time. Just looking at the procedures in place, written procedure and who was responsible for those, a policy, put a procedure in place, looking at a person responsible for each of those issues, and in most cases a backup for that as well. So a lot of work with the emergency plans and back and forth with the camp, because any one cookie cutter for a big camp system, we didn't just take the cookie cutter. It had to be made for that camp and really refined for that each particular camp environment. So looking at those, these were some of the common deficiencies that we found with the plans. Again, having people identified to take those responsibilities and a backup. As I mentioned, fiber internet, maps on the flood way and the flood plain were also important for these camps. Then we got into the inspection phase. As I said, all of the camps got a pre-licensure inspection, a chance for them to respond to deficiencies that might have been noted there. And then once camp season started, we're doing an operational inspection on all of the camps that are licensed. The numbers this morning, we had 7 of the approved camps that still had not had their inspection. Some 300 odd had been inspected twice, pre-licensure and their operational inspection. At the end of the day, we will have approximately 3 camps left that haven't had their operational inspection. Most of those are because the camp was, it might have been a new camp. Some camps are not in operational the whole season, so they have they're not starting until later in the summer. I think most of those will, operational inspections will occur the week of July 20th. So we really front-loaded those inspections during their operational season, primarily in June, trying to get there early on in their operational season. And then just looking ahead a little bit at some lessons learned and continuing actions going forward. We're doing the inspections, as I mentioned. A lot of the day camps did not, again, they're not overnighting campers, but some of the day camps have a provision where 2 nights during their operational season, they might have some campers overnight. So if they had cabins, all of the requirements for a residential camp they had to comply with. They were some of those camps were not aware of that, and so that was working back and forth with some of the camps on those expectations. Emergency plans, just the new statutory requirements that they needed to implement in the plans, and then working with experts with NEMR, really looking at operationalizing those emergency plans and making sure they were effective, rigorous, and could be tested and sustained. A lot of those, again, new provisions, new requirements for the camps to implement, and so working back and forth with those took some time, a lot of dedication by NEMR and the camp operators themselves to put those into place. Looking forward, we have the multidisciplinary safety team that we're pulling together from experts from state agencies. We plan to have that first meeting August-September timeframe of this year. Those experts will continue to give us advice on the rules, the implementation of these, and where necessary, statutory suggestions on statutory revisions as well. So we're constituting those and look forward to having further advice from these experts and then moving those forward with a whole of Texas agency response to those. Similarly, we have the Youth Camp Advisory Committee that will be convening in this. We just closed the end of June the applications for the Youth Camp Advisory Committee members, newly constituted with some experts both from campers, the camper community, as well as expertise both in operating camps and in some of the requirements, whether those be water safety. There's a requirement for a pediatrician or a psychologist to be on the Youth Camp Advisory Committee. So some new criteria for the members of the Youth Camp Advisory Committee. We'll look forward to having that group work together with us and to provide some other feedback for us. And then finally, just looking forward to the session that will be here shortly. It feels a little bit like session's here already with interim charges, but we know session will be just around the corner, and potential to revise the statute as necessary. Just a couple of issues and things to consider, just the involvement of local emergency management coordinators. A lot of emergency management coordinators across the state, quite a variety, and so just looking at their engagement both before camp season starts and during the season. Some opportunities there. Giving the department this particular statute gives the camp operators due course and due process. But if the department identifies issues that we consider serious, that they shouldn't be operating, we're somewhat limited on our legal authority. We have to run those through the due process, notify the camp. They could, in many cases, go to an administrative hearing, which might take weeks or months before they get a chance at the administrative hearing docket. And we do have an alternative path where we could take them for a temporary injunction through the Attorney General's office, but that's also, it's not, in some of our other programs, we have a little more defined opportunity to intervene and to either pause a license or an activity while the due process, while the licensed activity works their way through the due process, that we could cease that operation, and we don't have that authority in these camp programs. So that's something else for us to consider moving forward. And then the last bullet on the slide dealing with the definition of a youth camp, there's some potential, our rules say that a camp, to be a licensed youth camp, they must be operating 4 days a week. They must have 2 outdoor activities that the campers participate in. Some camps have chosen that they didn't want to operate as a youth camp. They wanted to curtail their operation to be more like a daycare or a child care operation, not having outdoor activities. And in those cases, we informed the camps that most of those withdrew their application, or there may have been some of those that chose not to apply for a youth camp license, but they may be operating more as a daycare or child care. We've informed those camps that they may have requirements with HHSC as a daycare or child care operation, but just making sure that those seams work together for camps if they really are. What's a clear distinction between a youth camp and what should be licensed as a youth camp and what may be more appropriately licensed as a daycare or child care? And then the last, just another consideration I did mention, end-to-end fiber is turned out to be a challenge that some camps just could not overcome based on their, you mentioned waking up in a rural part of the state this morning. Senator Colkhorst, many of our camps are in those situations and have absolutely no opportunity for end-to-end fiber. So, and the department did get, or that statute was enjoined in a lawsuit for this camp season. There was a settlement to allow the enforcement to go until the March timeframe, approximately this coming year. So those camps may continue to operate as long as they have 2 redundant systems. But that is one other consideration for the legislature to consider. If that's critically required for the health and safety of campers, or if multiple redundant alternate systems of communication could also be effective. So with that, ma'am, I'll stop and be happy to try and answer questions.
Thank you, Dr. Stevenson. Senator Blanco.
Thank you, Madam Chair. Thank you, Dr. Stevenson, for your information. I just want to clear something up on slide 12 under emergency plans. You said it was unclear how many camps collaborated with local emergency management prior to submitting their plans to DISHs. And then on 15, some of the considerations you have for the 90th session under emergency plans, the local emergency management camp coordination. Can you
Yes,
can you give us a little more detail so we can get some ideas?
Yes,
of
sir, absolutely.
And understand, some of my rural communities, it's the county judge. They don't have an emergency coordinator, and that could pose some challenges as well. So I'd like to see what you have in mind.
Yes, sir. Thank you for the question. The statute requires that after an emergency plan is approved by the department, the camp submits their plan, work it back and forth, it's approved, that they must submit that to the local emergency management coordinator. That is happening. But then in terms of, it seems like there are opportunities before a camp, an emergency plan is approved, when they could work back and forth with the local management coordinators to see what the county has or the jurisdiction, what the camp's expectation, what the county has to offer, and collaborate on that beforehand. Many of the camps did that on a voluntary basis, but it wasn't required. Some of the local, again, the resources that they might have locally varies significantly between the state. So I think that's the opportunity there, that perhaps they're required to collaborate on some of those things beforehand. Again, they are filing their emergency plans, so after it's approved, they know what each is supposed to do, but probably some beforehand. And again, I think, sir, you mentioned the variation across the state, so perhaps it's hard to write a statute that forces everyone to do the same, but those are some of the things we could consider. Yes, sir.
Great. I'm going to follow up on Senator Blanco. In looking at some of the camps, I'd certainly received phone calls. I sat down with several of them. Now, some of these are rural camps, Bible camps, smaller camps, not your, what I would call legacy camps.
Right.
And the fiber issue was really kind of a game changer for all of them. I have Camp for All in Washington County, which is a camp for children with disabilities, and to look to run fiber. They have one camp, they're proposing another one. Senator Cook, it serves Harris County. It serves children from all over, but a lot of pull out of there, again, for disabled children. And to run fiber, the numbers I saw were staggering. It's
Yes, ma'am.
more than thousands. You're
Some
getting
hundreds, $200,000, $300,000 we heard quoted.
$1 million, okay? And so, because again, you're running this.
Right.
I do grow up in a rural area. Starlink is a gift.
Right.
I used Starlink this morning before I left Washington County. So let me ask this as a question. I know the Lieutenant Governor and the Speaker of the House both wrote a letter. The law says, there are no waivers. There kind of were the lawsuits that enjoined it so that they could do this. Do you see a problem with redundancy being two different satellites?
I do not, ma'am. I think that gets to the intent of it. These statutes were put in place fairly quickly, and everybody's learning about some of these things. I don't think anybody knew at the time how many of these camps would have access to fiber. I did not see an issue, though, with redundant separate means of...
So one of the camps that I sat down with was like, I don't have a problem with redundancy now, and again, you're looking at affordability, but it's important, okay? But the redundancy is there. But then he pointed out to me, he goes, when the power's down, it doesn't matter. It doesn't matter if you have fiber. It doesn't matter if you have 2 satellite dishes. Mm-hmm. And he was so profoundly looked in my eyes and said, you probably should have required a generator.
Or a radio.
Yeah. So, long story short, I think that we should really look at that in the interim of, redundancy doesn't work if you don't have power, right? Seriously. Once the power goes out, trust me, I went on a vacation in the mountains, and the power went out, and the satellite didn't work. It didn't matter if we had 5 satellites on that roof. It didn't work without power. So I and y'all didn't make that suggestion. That came from a camp operator. So I think that's an important point. I also want to go to your definition of what does it, the youth camp definition. I think you've met with our staff several times and said it's a little ambiguous. There's also a large variety of camps that do and do not meet DISH's definition. Sports camps, camps run by a university. And so, today we're asking questions. It's the interim.
Right.
What would you recommend on that?
I think some clear guidance on what would go to a daycare camp, child care. This definition that we have with the 2 outdoor activities was a collaborative effort of Youth Camp Advisory Committee, campers, feedback from stakeholders, looking at what they really envision and in their mind when they think of youth camps and the activities that they have in the outdoors in summer. These were the recommendations that we had from a lot of stakeholder feedback and operators.
So during the flood hearings, Senator Menendez suggested maybe regarding some of the camps, run it like CCR, the child care regulation kind of issue. So could y'all work on that and make some suggestions? Again, safety as first and foremost. Not all camps are alike. I think we all look at these as Camp Mystic, Camp La Junta, Camp Longhorn, Camp Champions, but there are a lot of different camps out there that, and again, child safety, because we license those.
Right.
That there should be the utmost, a priority for child safety. But also, again, not all overnight along the river, etc.
Right. Small camps, big camps, a lot of variety out there. Yes, ma'am.
Okay.
Looking at those.
And
We will.
then I wanted to go to page 8. It was interesting to me of the deficiencies, and was there one of these, did you rank those in order, or was it just, it appears potentially just to be alphabetical?
No, yes, ma'am. Those are alphabetical. The assigned roles, having a person assigned to the role. A lot of the camps wrote down what they were going to do, but they didn't necessarily, on the first draft, assign that to a particular person and or a backup in case the one person wasn't there. That was a common deficiency that we had. Of course, we mentioned fiber already.
I would think that probably ranks pretty high as the
Yes,
fiber deficiency.
Yes, ma'am.
On the warning and PA systems, did most of them have PAs or not?
A wide variety there. Again, to your comment about one camp is not like all the other camps. Some camps are pretty much on one campus, and everybody could be in earshot of a bullhorn or a one camp speaker system. Others, they put them on a van or a bus, and they go to a different part of the campsite itself for some activity, waterfront activity, a ropes course, a challenge course. Again, getting them out from the cabin, which is a good thing for a lot of parents and kids. It's a goal, an aspiration that they not just be indoors all the time, but you bring in the variety, and then one camp system with a speaker doesn't reach that. So how do they get to maintain communication with the radios and or cell phones for those chaperones that are with the kids? And then how do they, from there, contact all the kids if a storm's rolling in or they need to notify the kids and the counselors? So a wide variety there on the PA systems. Some camps had, and again, the unique situations was a little harder for them to put something in place that could assure us they had communication and also feasible to implement.
What we learned, and I think the most important thing, members, is to take away from this is through all the hearings was assigned roles and responsibilities and making decisions and leadership, and the young ladies at Mystic were literally steps away from safety and lack of making those decisions. Page 3, 378 camps in 2025. I think you revised it to 307 camps in 2027. So net 71 camps gone because of the camp regulations.
Mm-hmm. Yes, ma'am. That's the net. About 107 that had a license the year before did not. Then we had some 30-odd camps, a little more new applications.
And some of those camps could, and one of them is Mystic, being they did not receive a license.
Right.
Some of those camps could come back. Is that a have you been in contact with them?
Absolutely. I think the fiber question was for some camps, again, on the 107 that did not apply this year. We don't have data on all the reasons they did not. Some of that anecdotally, talking with our staff, they didn't have fiber, and so they just weren't going to put in their application fee, not knowing what would happen with that requirement.
And then lastly, I think one of the complaints about our licensing of camps, you had an inspector that went to Mystic, I believe it was on July 3rd, July 2nd or July 3rd. I believe.
Second, yes, ma'am.
July
I
2nd,
think so.
okay. And it seemed that we were more focused on food safety than perhaps all of the other issues that we now have before us or what failed at Camp Mystic. You mentioned that y'all have, and we appropriated that money in the second call session. We gave you more inspectors and more FTEs.
Yes, ma'am.
And so, to the public that is listening, we're more than a food inspection organization at camps now.
Yes, ma'am. Absolutely.
And you feel like the expertise, you bragged on the expertise.
Really, the expertise of the team. We still have sanitarians with their expertise, but we have emergency program management coordinators, and one of those was incredibly helpful for us. I won't mention her name, but she was fantastic. She was an absolute godsend. National Emergency Management and Response, they helped us immediately, especially with this transition, bringing on this expertise this year in a hurry. So they helped us. We're developing, and we have some expertise in emergency management and just really looking at the team approach. So any one person doesn't know everything related to all of these activities.
Thank you, Dr. Stevenson.
Yes, ma'am.
I appreciate it. It's a very serious matter, and I know this legislation is being looked at in other states now. And again, our prayers with the families of Camp Mystic who lost a loved one, and to all those, I believe 138 in total of lost lives on the July 4th floods of 2025.
Yes, ma'am.
Members, any other questions? Thank you. Mr. Kostrom,
Yes.
you're up.
So we are going to, is this on House Bill 3595?
Yes, let's go
Okay.
3595.
All right. We're going to report on our progress of 3595, which sets readiness standards for assisted living facilities during outages. And you mentioned generators, and there's a requirement here. Michelle Dion-Vahalik is our Deputy Executive Commissioner for Long-Term Care Regulation.
Good to see you again.
And she is going to walk through these requirements.
Do you want me to flip the slides?
Bet you can do it.
Yeah, we'll give it a shot. Okay, starting on slide 2, House Bill 3595, which pertains to assisted living providers. On the right-hand side of the slide, you'll see a timeline where the law became effective on September 1st, 2025, and it moves through implementation and when providers are to have certain things in place, with the majority of requirements coming into effect on January 1st of 2026. The requirements, basically the core requirements are they do have to have a contingency plan, and that is to have some sort of alternate power or contingency in place when the provider loses power for up to 12 hours. If the provider should lose power for up to 12 hours, there is a requirement for them to notify HHSC. They also have to designate an area of refuge, and that area of refuge must be a minimum of 15 square feet per an individual and maintain temperatures between 68 and 82 degrees. They also have to have a relocation plan that includes moving to the area of refuge, and it can also include evacuation to another site. If HHSC determines noncompliance, we are able to assess penalties. Moving to slide 3, an implementation update. We just recently put out a provider letter that speaks to the general requirements of the law and that we will begin surveying and enforcing on 9/1/2026. Some of those requirements include making the plans available to HHSC at any given time. They are reviewed during annual or biannual surveys, and anytime a surveyor goes out and there's a question over emergency preparedness. They must provide a summary of their emergency plan to each resident. They must report power outages to us if they last more than 12 hours. They must define the area of refuge, maintain certain temperatures, and provide emergency power connection to maintain temperatures for facilities in areas of refuge. We are going to begin training as of tomorrow, providers on emergency preparedness, which will include these requirements, as well as surveyors. And trainings will continue between now and the end of August so that providers are able to ask questions, receive some technical assistance, and be prepared for the survey and enforcement of these requirements. Moving to slide 5. This is just a recap that we'll begin surveying on September 1st. There will be rules promulgated for the construction requirements, and we anticipate those rules being adopted the summer of 2027. Moving to slide 5, it talks about our normal overall emergency preparedness, which includes pre-disaster, during, and post. We do have an alert media system, which we utilize, and we do notify providers of anything that we're becoming aware of. That can include incremental weather, upcoming hurricane, freezes, etc. We do remind providers to review their emergency preparedness, become prepared, and be ready. We also will notify regional offices to be monitoring. We also tell the providers to notify our regional offices if there is any issues with during the emergency or post-emergency. And moving to slide 6, this kind of walks through what we actually do to ensure that our providers have the information, are ready for the disaster or the emergency, and then what we do during and post-disaster, which includes monitoring and collection of information. This can range from information going out through our alert media. We will make call downs to every single provider that could be in the impact zone, pre, during, post, if necessary. During disaster and post-disaster, our calls and alert media messages can include, please notify us of the need for any type of emergency need, resources, etc. Are you sheltering in place? Do you have access to everything that you need? If we become aware of any pending need, we will coordinate with our emergency preparedness partners through the State Operations Center. And if we become aware of any need for evacuation assistance, we will also report those immediately to the State Operations Center. And that really concludes my presentation, and I'm happy to answer any questions.
I think we probably will have some testimony. I don't just. The Texas Backup Power Package program is under the PUC, but do you have any sense as to how many assisted living facilities have decided to use the program given the mini grid requirements? Do you know?
I don't have that information.
Okay. All right, that would be a PUC question that we'll kind of have to look at and see if any have applied for the grants or anything else. So it'd be interesting to see. So far, so good? Really just kind of wading into it?
So far, so good. When we drafted the provider letter to go out with the general requirements, we did work with the provider associations to ensure readability to the end user, their providers, and to ensure that we were all on the same page with the general understanding of the law requirements.
And any pushback?
No,
Okay.
not so far.
Okay, great. I know Senator Miles is very interested in this, and Senator Alvarado. We had many iterations go through this committee, and I'm sure there will be follow-ups to those issues. So thank y'all for what you do. With that, that concludes all of the panels today and the invited testimony. We will now move into the public testimony, and we've tried to do the best we can in kind of separating out. We'll start with the surrogacy charge and then move into the monitoring charge. As a reminder, you must be registered to testify. If you're wishing to speak before this committee, there will be a strict 2-minute time limit for each person unless we ask a question. It is the interim, so I'll be kind about that, but we have quite a few people that have registered to vote. And again, I know members are moving in and out, and some had to leave early today. This will be on forever, taped and recorded. And so I know members have told me that they will be looking for the input. And at this time, it is 12:20. We have how many registered? 31 total witnesses. So we're going to go ahead and close registration at this time. If there's no objection, registration has been closed. The chair calls Vanessa Sivage, Dr. Joe Poyman, Josh Wood, and Sarah Eidos, or Erdos. Yes? No? None of you are here? Okay, so we'll come back to that. And anybody that is out there in the hallway, and if you have a friend out there, just let them know we're starting public testimony. So we'll move on to the next four. Ashley Sosa, Whitney Scheibner, Krista Haroff, and Lori Anderson. And we'll call one more up, which would be Emerson Carl. Emerson Carl? Carl Emerson? Okay. How about Miriam Shahab? That'll get us all four. If you will, state your name for the record, who you're with, and you may begin your testimony.
My name is Ashley Sosa, and I'm the Communications Director for Texas Alliance for Life. We are a statewide nonprofit organization committed to protecting the fundamental right to life of all innocent human beings and promoting respect for their value and dignity from conception until natural death. I'm here today to share our serious concerns about the current surrogacy landscape, which allows for exploitation of women and exposes vulnerable babies to contractual abortion. We believe in protecting the sanctity of life and the dignity of both women and babies. The dignity of a woman is undermined when she is bound by a contract that pressures her to abort the child she is carrying. The dignity of the child is destroyed when in a contract that child must pay with their life if they are somehow deemed deficient or unwanted. Multiple media outlets reported the story of Brittany Rose Torres, a surrogate carrying triplets. The intended parents told her to abort one of the babies, citing the contract that gave them the authority to make that demand, and they withheld payment as leverage unless she complied. Brittany Rose offered to adopt the baby girl herself, but the parents refused. She ultimately kept the child. In another documented case, a surrogate was pressured to undergo a selective reduction after the intended parents discovered one of the twin babies was diagnosed with Down syndrome. His life was considered disposable simply because he did not meet their expectations. Most surrogacy contracts include terms authorizing termination and selective reduction. We believe all life is valuable and worthy of protection. Texas Alliance for Life supports common sense guardrails that protect women and the lives of babies conceived through surrogacy, even at the earliest embryonic